May it please your lordship. My lord, with regard to the custodial date of case of Kohima, a concise note I will hand over to the bench system. Yes, please.
May, please, your lords. My lord, orders matter item 41, my lord. Matter has become infructuous, my lord. 41 orders.
And 42.
Put,
What about 40 and 41?
my lord.
There are two matters tagged
Yes, yes,
together.
I am a 7 to 5 one I am.
What about the other one?
Matter has become other one, my lord. That is another council matter. Perhaps that matter has also been become infructuous as per instruction of my client.
Anybody
it is- I am
for
not
the
on-
other matter?
That is a Mundal, my lord. M.A. Mundal. But
What
my
is the matter about?
about my lord, regarding my lord, the retail license of a society was suspended. That has been deferred by the honorable court. But there, prior to that, the PDS item of that license were tagged with another nearest society, my lord. So that has also been stay interfered by the honorable court. Even then, my lord, the tagged society did not allow the problem.
You are Mr. Rahman.
Yes, please.
We'll have it together. We'll see at
Then-
that point of time. Because there are two matters together.
May it please, your lordship. Lordship, I beg to mention item number 17 of today's list. my lord.
Hmm.
My lord, in this matter, my lord, as per the instruction, this matter, I am not pressing this matter, my lord.
Mr. R. Islam, appearing on behalf of the petitioner, submits that he had instructions not to press the incident repetition. Accordingly, the writ petition stands closed on withdrawal. The interim order, if any, stands vacated.
Lordship, I am for respondent number 5.
Much obliged.
So and so appears for a respondent. Yes.
That is a lordship. My lord, as regards item number 37 of today's lead, it's a content matter. The petitioner doesn't want to pursue this matter anymore.
What?
Item number 37, my lord.
You cannot say that you cannot pursue.
Because,
It's a contempt matter. Either it has to be complied with or not complied.
no, my lord, there are some development.
There is no developments. Once a contempt notice has been issued, it is final.
My-
It is not between you and this court. It is between this court and them. So the question of not pressing does not arise. Rejected prayer.
May I please,
Next.
Lordship? With a consider order said, I beg to enter item number 47, 48 and 49, Lordship. In this case, Lordship, today is the returnable date and Lordship, we have entered our appearance by filing Ugalatama on behalf of the respondent, Lordship. Lordship, may kindly grant us 4 weeks time for filing our response, Lordship. All three content.
This is for contempt.
Yes, Lordship. Today we have filed
You
Ugalatama.
are asking file to time for filing
Yes, response.
wakalatnama.
Today filed, Lordship. Morning today we have filed. Lordship. For filing our response, Lordship.
4 weeks time given to Mr. K. Kolita appearing on behalf of the contemner. For filing their response. List the matter again on 15th of October 2025. The affidavits be filed without fail by 13th of October 2025.
Hello.
May preserve. I beg to mention item number
That is
15.
beleg order.
Item number 15. This matter has become infructuous, madam.
1-5,
1-5.
it's, what's your name?
Bora.
Ibora. Appearing on behalf of the petitioner submits that the writ petition has become infructuous. Taking into account the above, the writ petition stands closed. Interim orders, if any, it stands vacated.
My please, your lordship. Lordship, my prayer for listing this writ petition, your lordship, day after tomorrow, your lordship, on 28, along with WPC number 4660 of 2025, your lordship.
Why?
It's a tender matter, your lordship. Initially, 2 persons submitted the WPC, your lordship, and on 14 August, your lordship, this petitioner name was withdrawn, your lordship. With
Huh?
liberty, this petitioner's name was withdrawn on 14 August with liberty to file a fresh one, your
So?
lordship. For
Why do you
tender
need to
purpose, your
another
lordship,
one? Not necessary. No.
and
If you file it, it will come. Otherwise, no,
lordship, there
not
is a
necessary.
order to
I
extend the
remember about that the micro and all.
lordship,
I was stated,
lordship,
isn't it?
lordship. It's
So
on
it
20,
will
lordship, that
it
matter.
will impact everybody.
That
I
there
have
was-
directed extension of the period beyond 22nd,
Lordship, Lordship,
isn't it?
Lordship.
Your file, will see.
Oblige, your Lordship.
May I please, your lordship? Lordship, the concern of the other side, I beg to mention item number 27, your lordship. In this matter, Mr. D. Gogoi is appearing. There's a bereavement in his family on Saturday, so he's not available today, your lordship.
What is this? I said, you don't want to press. What do you want?
With Mr. D. Gogoi, he's appearing, lordship. There's a bereavement in his family, your lordship. So it's not available today, your lordship. After 2 weeks, your lordship.
At the request of the council appearing on behalf of the petition, to the effect that Mr. D. Gogoi is having a bereavement in his family, the matter stands adjourned, be listed after 2 weeks,
Let it be 3 weeks, your lordship. 3 weeks?
to be listed after 6 weeks.
Oblige.
I beg to mention item number 50, item number 50,
1550.
50. Lordship, on the last order, this court directed to file an affidavit. So we will be filing it today, Lordship. So if the matter may be
Been
adjourned. for
submitted
today.
by the learned counsel appearing on behalf of the petitioner, that the affidavit which was directed to be filed by the petitioner have not yet been filed. Taking into account the above, list the matter of the 4 weeks. If next,
Praying for listing of a writ petition, my lord, on motion, my lord, day after tomorrow, my lord. Urgency is, my lord, day after tomorrow, my lord.
urgency,
My lord, the facts is that, my lord, petitioner availed a loan, my lord, while purchasing a vehicle, my lord. Thereafter, he was clearing his EMI, my lord. By, without following any due procedure, my lord, that vehicle has been taken into position and they are going to sell it on 21st of August, my lord. So I'm praying for listing this writ on 20th, on Wednesday, my lord. I'm deeply obliged.
Top of the list, item 1.
yes, what has happened to that rules? Any development?
But that will be, Uh, on last occasion, my lord, we have apprised that the Industries and Commerce Department, they have sent back the file to resubmit it, and accordingly it was resubmitted, my lord. My latest, the information which I received on Saturday, it shows that their view is awaited, my lord. It has been resubmitted by the Labor Department and it is with them, my lord.
Why is the Labor Department not doing anything?
The Labor Department has, my lord, kindly see the last instruction on 14/7/25, my lord. They have informed that the Industries Department have sent back the file with a request to resubmit the file.
Appearing on behalf of the state of Assam submitted that on basis of the inputs, the industries of the Iman has placed the matter again before the Labor Department.
Lordship, lord. It
This
was,
happened on 15/7/2025.
my lord, it was sent back, my lord.
We are
By the Labor
concerned
Department.
here. Almost a month has passed by.
It already Labor Department has placed the file before the Industries Department. The Industries Department's view is awaited, my lord. That,
But
It-
here, what is this?
lordship,
File has been sent back to Industries Department for the review, which is yet to be received.
lordship,
So it is now with the Industries. Department.
Industries
Who
Department.
appears for the Industries Department?
But now we are appearing, my lord. Earlier they have sending council, now we are appearing, my lord.
So how much time now you,
My lord, I'll take the instruction from the Industries Department.
so you should have taken the instructions as you are appearing for the Industries
Well,
Department.
On the last hour in this, on Saturday, I got this, my lord. I need some time, my lord. By today, I'll get the instruction.
How much?
But from the Industries Department information, I can take it, my lord. By today, I can take it, my lord. I can apprise the honorable court.
Sure. 2 o'clock?
I
Take
guess,
the instructions. When, how much time does the Industries
lord,
Department
that,
require?
that I'll add.
Then we'll fix the matter on that.
My lord. Lord.
2000.
For motion item 2.
My lord.
Take on Friday. Nagaland to Assam. Matter on Nagaland. Yes, what is this, Mr. Bush?
My lord, by way of additional affidavit, I have brought the legal notice, my lord. That is at page 20 of my additional affidavit. My lord, this notice was issued and
The
on-
Secretary Tribal Affairs.
my lord, my lord.
What was the direction here?
My lord, direction is at page. Page 14, my lord. Of my contempt petition, my para 8.
No, why the matter has been listed there?
My lord, earlier, on earlier occasion, my lord, I could not find the legal notice informing the respondent number 2 and 3.
Oh, this.
That's why my
Lecture A2.
A2, my lord.
A2 was sent on when? 18/7.
18/7, my lord.
18/7.
By registered post, my lord.
18/7. So we'll take it 7 days.
My lord.
Registered post.
My lord.
So 7 days if it has gone, so it will be 24/7, 28/7,
My lord.
18/7. You sent it on 18/7.
Yes, my lord.
Then how the 4 months is not over? How is it possible?
My lord, then my lord, only I may be,
No, mister. This was sent on 18/7.
18/7.
4 months time was given for purpose of verification.
My lord.
Then how is it maintainable?
My lord,
How is the contempt?
against the say principal secretary, my lord, I have sent a notice on.
All are on 18/7.
No, my lord.
Yes.
Uh,
Kindly see annexure A2.
Kindly come to page 16, annexure 2 of my contempt petition, my lord.
Yes.
Upon the secretary, we have furnished the copy on 17/3, my lord, and he has received that 17/3, my lord.
Who?
Office of the
There's no seal, nothing out there. What is this? It has been received. How can this court draw contempt like this?
the seal is above, my lord.
What seal is this?
Towards 17/3/25.
It
The
has been
ground
given
seal,
to whom?
Original copy, this one. Original copy. Yeah, original copy.
You wait. It's seen only you have sent. That it is a legal notice dated 11/7 issued to the contender for the purpose of reminding here. 11/7. 11/7, 4 months is what?
On the respondent number 2 and 3,
Was issued on
11/7, my lord.
So 4 months will be over in the month of November.
My lord, kindly see one thing, my lord. On respondent number 1, it was furnished to him on 17/3 itself, my lord.
No, this is no.
That is the seal of receipt, my lord.
No.
Kindly
You have not
come to.
issued it to the other two and three.
No, I may be permitted to delete their name, my lord.
So
Only
you have
principal
not-
secretary, my lord.
Huh?
That will do, man. Only principal, respondent number 1, man.
What one? Respond number 1.
I'm not tracing against.
So you are issuing the notice on 18/7 only.
No, that is the legal notice, my lord.
Where is the legal notice?
Legal notice is at
No legal notice business.
additional affidavit, my lord.
Where is the legal notice? It's the same date, 17/3.
Legal notice is 11/7/2025.
Where is
At
the
page 20 of my additional affidavit.
page 20? Now this is being sent. So why should we
My lord,
wait? No,
my lord, notice was served on the respondent number
they
1.
were given only 4 times. And you, how can it be to the respondent number 1, taking into account that on 17/3 it was to the Secretary Tribal Affairs? See, it is given to the Secretary Tribal Affairs. See that to whom you have.
My lord Secretary
Secretary
Tribal,
Tribal Affairs is not the BTC president.
my lord Secretary Tribal Affairs, this,
This
that
is
is the
the
new
respond-
designation, my
This
lord.
is the response number 2.
That is the new designation, my lord.
No. Kindly see page 3. Akashdeep IAS Principal Secretary BTC. Number 2, Sujit Baglari, ACS Secretary Tribal Affairs.
My lord.
Eh? Read this.
So,
This notice is only to that, and that too, we don't know whether it has been received by somebody else.
my lord, this
Where
is the
is the
seal, my
seal
lord.
out here? No.
My lord,
I
this
think
is
you
the
need
seal,
to-
my lord.
You wait, I give you the liberty. After in November you file.
My lord, this notice was served upon.
No.
My lord, I will satisfy, my lord.
I'm not satisfied. I
My
gave
lord,
you one chance.
let it be after a week, my lord, I will satisfy.
Yes, better off. You can satisfy some other court, not me. This is the matter of the one.
3 is same, my lord.
This is the matter of the one.
Item 4.
Yes, what is this?
Matter may be passed over for the time being. Lord.
Why?
Let's say my senior S of will appear in this.
Huh?
S of will argue this matter.
What is there?
He is
Directing ER to and fro not to award a PhD degree to the respondent number 6 for violation of the revised PhD regulation and or cancel the PhD degree of the representative already awarded. Huh? You are,
My lord, I'm for the university, man.
why is he against?
My lord, she is going to filing, my lord, one after another RTA application. For total, she has filed 4. 3 we have replied. My lord, 4 on repeated query, my lord, that was rejected, refused. Then she went to even a
Yes, Mr. Hawk.
second appeal.
My lord,
Ah.
here,
Another.
Borderland University is doing, my lord.
Huh?
Borderland University, how they are awarding the PhD degree, my lord. There is in guideline, my lord, of 2020, my lord. In total violation of that guideline, my lord, they have favored that officer, my lord, who was serving at the time of, my lord.
Who are you?
Right now, my lord,
Who are you?
I am the RTA applicant, my lord.
Huh?
RTA applicant, my lord. I have sought some information, my lord, as to, my lord, how an IS officer, my lord, who is serving as the district commissioner at the relevant point of time, my lord, at the same Kokrajhar, my lord, how she got registered as a PhD scholar, my lord, without availing any kind of leave. I have annexed all the documents.
Mr. Day, you have got your PhD degree.
No, I'm for the university, my lord.
Huh?
My lord, the
You are appearing for whom?
respond number 6 is the candidate, my lord.
Who are you appearing for?
University, my
So
lord.
just now you said you are appearing for the response number 6,
No.
isn't it?
I will be paying for the personnel department. Respondent number 6 has been, by name has been
Ah.
raised, so
Ah.
notice has to go on.
The Notice will go, but you are the Boroland University.
My lord.
Have you awarded the PhD degree?
No, the Bhaivavasi has been fixed, my lord.
Okay, what is your basis on which you are awarding PhD degree?
Basis, my lord, she has submitted thesis. So, Bhaivavasi has to be convened.
For PhD, you require an enrollment,
Yes.
and for the purpose of
His
enrollment,
allegation is that, my lord, that respondent number 6 did not attend the required 70% attendance in coursework. And then, my lord, no NOC from the government was produced for pursuing the PhD course. That was his allegation. We have already replied, my lord.
where is your reply?
Reply, my lord, in the writ petition itself, my lord.
Well, Your Lordship, my lord, I am coming to the point, my lord. Your lordships come to, well, their reply.
My lord, page 43, 49, 50.
Well, page 71, my lord, you're showing fine, my lord.
Where?
My lord, this is the memorandum of settlement with of the BTC, my lord.
Mr.
Here,
Hawk,
my lord, my lord,
Mr. Hawk, when you are filing RTI,
my lord.
have you got any reply from Boroland University?
Yes, my lord, they had contacted.
No, wait. Where are those?
Yes, my lord.
Where are those?
My lord, kindly come to, my lord. Page 54, my lord. 54 and 58, my lord.
Page 53.
54, my lord.
No, page 53.
Yes, my lord. Here, my lord,
PhD entrance result sheet as for AI is enclosed as annexure 1.
my lord. Now come to, my lord, next page, my lord. One informative reply, my lord. They have said that he had the requisite attendance, my lord. And subsequently, they have page 58, my lord, they have said that we had no attendance register right now. Well, how they can contradict their own statement, my lord, in the RT application, my lord. Page 58, your lordship will find it.
But how do you maintain a repetition being a RTI?
My lord, here, my lord, petition submitted her application, my lord, under the
Understood. You are
Right
an
to Information
RTI.
Act, my lord.
How are you a person aggrieved? You are asking for a what read? Read for?
My lord,
What read are you asking for?
my lord, asking for the cancellation of the,
What is a read you are asking for?
my lord, under 226, my lord,
226 is different. What type of read you are asking for? You have to know.
certiorari, my lord.
Certiorari, how can you, a person has to be a person aggrieved.
My
How
lord,
can you ask for a read for a certiorari if you are not a person aggrieved?
here, my lord, they have, yes, my lord.
Mr. Hawk, I think you need to prepare your brief properly. What type of read you should know? Then only I should know. Otherwise, for a certiorari, you have to be a person aggrieved.
My lord,
You are not a person aggrieved. You are not affected by a PhD being granted.
yes, my
So what type of read are you asking? You read the Mr. V. Ramachandran's law of reads, then come back to it. 1 week time grant. List the matter of the 1 week. Then only read it. You can't come before this court like this.
Item 5,
Oh, what read you are
My lord,
asking?
my lord. Yes, I'll have to, I'll just have to tell you, lord.
Yes, read the two books, P. Ramachandran's Law of Reads or Mr. Justice Banerjee's Law of Reads.
My lord,
Read those, then you will know what read you are asking.
my lord. Any date, my lord? Next week, my lord. Publish, my lord.
What is this?
May I please, your lordship? My lord, electric
Tempering of
connection was,
energy meter depriving him from essential service.
yes, lordship.
Lordship, we are indulged in theft of electricity under section 135. So once an assessment bill has been drawn, he has a remedy under section 126 if he wants to avail. He has not availed that remedy.
Have you made the provisional bill?
Yes, the bill has been.
Provisional, I think that you have made a final assessment.
No, if your lordship, the wording of section 126 is such that if the person does not file a objection against the provisional bill, then it automatically becomes final. So if he wants to file an objection, then he should file an objection against the section bill under section 126. Then he can be heard, and then the proceedings under section 126 will take
So
place.
this, what is page 20 of the writ petition, Annex 6?
But I approach the authority, lordship.
Huh?
I approach the authority, lordship.
No, page 20.
Page 20 is the final assessment bill, your
So
lordship.
this is the final assessment bill.
Yes, your lordship.
2,57,000. Have you paid that?
No, lordship.
Then how can I help you?
Because we say this this bill is not a proper one, lordship. It is
Understood.
an allegation, lordship.
Yes.
Allegation that I
So
tampered with
these
the.
people must have gone to your place, made an inspection, found out that there was a theft. on account of temporary. You say that there is no temporary.
Lordship.
So they initially make a provisional assessment bill
Okay.
under 126. Then you have a right to file an reply. When you file a reply, they may pass the final assessment bill or make the provisional assessment bill the final. Or if you don't file a reply, the provisional assessment bill becomes the final assessment. That's the law. Now the next question is, you have to file an appeal under 130(27). You have not. Now, how do I ask them that, look here, kindly provide the electricity to him if you have not paid the bill?
Lordship, I have not filed petition under section 127, but I have approached the authority. To
Approaching the authorities won't do. I think you need to properly read the Electricity Act 127 and move there.
Lordship, I may be given that liberty to file the objection under the.
It has already become final.
Lordship, but
I can't give it. See, the law says that you have to go under 127. Isn't? Were you given the opportunity or not? Yes, Mr. Where is the, here?
That is not indicated in the.
Estimate of the deposit of, where is the,
on the
your
day of
provisional
inspection
assessment bill?
itself, Lordship, on the day of.
Provision for construction of 11 kilowatt per day. Where is the provisional assessment?
That has not been enclosed in the petition.
Ah,
That has not been enclosed.
Lordship, on the day of inspection itself, the assessment was made.
where
at
is
the-
that document?
Lordship is there, that is there. Page 13, Lordship. Sorry, 16, Lordship, 16,
16.
yes.
Report of the inspection, testing, renovation, new connection carried out at the consumer. So Martini rice mill, inspection date, so sanction load 12 kilowatt per agreement.
Page 17, last
20 kilowatt,
11%.
Indian meter as per transfer. Right? On a random visit, the consumer meter has been found tempered, so the consumer comes under the ambit of the Electricity Act. LT cable. Yeah. So this is the provisional assessment bit.
This is the inspection report. Your
Then where is the provisional assessment?
And Lordship, may kindly see page 22 now. The date may kindly listen. On the same day, this bill was provided, Lord.
Huh?
Assessment was done on 22/10/22, and the bill was provided on the same day, Lord.
Yes, show me, Mr. Pathak, tell me what is this document? Is in such bad shape, the original one. Is this the final assessment bill, page 20?
Lordship, the original document provided at 22 does say final assessment bill at the top.
One thing, Mr. Kindly see. Inspection is of 22/10/2024,
Yes.
page 16, isn't it?
Yes. 22.
Yes or no?
22/10/2022, Lordship.
Yes. Now kindly come to page 20. Hearing date,
Yes.
24/11/2022.
But this is here on the same day, Lordship, may kindly see, down below, page 22. Date is written there, 22/10/22, on the same day, Lordship. I was not given any opportunity, Lordship.
Now, first of all, you produce a better copy of this. How do I know?
I have typed, Lordship, typed page 20, Lordship.
Huh?
To page 20 is the typed copy, and relevant date is page 21, Lordship. Page 21, the date.
No, then how can they put the date? Hearing date means what? Type of Iman, hearing date, why they have put the hearing date on 24/11/2022? Not clear. And you have not paid the amount.
No, Lordship, I have not paid.
Then how do they on the ground of law? Sir, I can't afford to pay so much, and it is my earnest request to you to consider the bid. How do I help you?
Lordship, it is
Tell
there.
me,
Hello,
give me
Lordship,
one rope or handle. How do I help you?
Lordship, I was not given any opportunity, Lordship. Lordship, again, this may be.
First
mistaken,
of all,
Lordship.
your document which you are enclosing is not proper.
Lordship, again, let's see.
I
their
don't know
document is
how
22.
you could read and translate it and put it properly in type it out.
Page 22 kindly may be seen for a moment, Lordship.
So how do I read it?
From the top, I have typed this, sir. I have typed out what page 20, Lordship.
Understood.
I have
Then,
typed.
then why there is a date mentioned?
This date is mentioned in their original copy, page 22.
Understood.
And they have put signature on 20, this is 24, puts signature on 22, Lordship. This date is listed 24/11/2022, and they have put signature on 22/10/2022.
I can't help you. You file appeal. Is there condonation permitted?
There is no condemnation provision. There is no condemnation provision. But
Or
your
they can
lordship,
file it.
under 127, because but your lordship may exercise powers under 26 and then perhaps permit them to file an appeal.
No, is the appeal required to be filed within a particular time? 127?
It's not mentioned.
Within 30 days.
How do I help you?
I may be allowed to file the appeal, Lordship, condoning the, maybe directed to.
How do I do it?
Maybe directed to condon.
You have all the way only woken up on 11 in 2023 and then in 2024, two documents. One is some, you can't file this type of cases like.
But I was approaching the authority, Lordship. Lordship,
Well,
can-
wait for another one more year. 1 year is over.
Lordship, kindly direct them to condone the delay. I will file, Lordship.
It is
appeal,
otherwise a
Lordship. That,
statutory authority. It is a statutory independent authority. We have nothing to do with it.
Honorable court can direct, Lordship,
I can't direct it.
for condonation of the delay, Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. KP Pathak. Mr. Gogoi, you appear for the power? Power?
Power department.
Mr. B. Gogoi appears on behalf of the learned additional 8A, appears on behalf of the respondent number 1. Mr. KP Pathak appears on behalf of the respondent number 2 and 3. The petitioner herein has approached this court being aggrieved by the non-consideration of the representation submitted to the respondent number 2
Three also.
for restoring the electricity as well as for restoring the electricity as well as to give special exemption to him. Full. This court duly takes note of that upon an inspection being carried out on 22/10/2022, an assessment bill was prepared under section 126 of the Electricity Act 2013. 13, na? 3.
2003.
2003. Amounting to rupee 2,57,002. Admittedly, the petitioner have not paid the said amount. The petitioner have also not placed before this court any document showing that the respondent authorities have the power to exempt after a provisional bill, after a final assessment bill have been prepared. Under such circumstances, the question of directing the respondent number 2 and 3 to consider the representation submitted by the petitioner by this court does not arise. This court, however, takes note of that if a person is aggrieved by the preparation of the final assessment bill, the consumer, he is a consumer, na?
He's a consumer. He's a consumer.
Will he come before the appeal or can he go before there is another one? Na?
No, because there is, this is an act of unauthorized use of electricity amounting to theft. It will go before.
Is aggrieved, if any consumer is aggrieved by the assessment bill prepared under section 126 of the Electricity Act 2003, the consumer has a recourse available, has a remedy available under section 127 of the Electricity Act 2003. The dismissal of the instant, the observations so made herein above, as well as the filing, as well as this court not entertaining the plea made by the petitioner, however, shall not preclude the petitioner to approach the appellate authority in terms with section 127 of the Electricity Act 2003. It is observed that in the circumstance the petitioner approaches, the appellate authority shall consider the same in accordance with law. But you don't have.
Item 6.
What is this? Non-payment?
Lordship.
How much?
50 lakhs, 87,378.
How much?
50 lakhs, 87,360.
50 lakhs, 87,378. Which police? What car you have?
Lordship. Four numbers are vehicle, Bolero, Winger, and this one.
Mr. B. Gogoi, Mr. B. Gogoi, just tell me one thing. I normally nowadays I've been passing certain orders to that effect. Is it not required that there has to be a service tax when there is a supply made by the person concerned to the government? Because you are a GST council also, that is why I'm saying. Here is a case they are providing services as regards providing hiring of the vehicles.
Lordship.
Wouldn't service tax be applicable?
That we'll have to check, my lord. Considering the tender terms and conditions, my lord, it will.
But then also,
My
it
lord.
is not a tender. These are all the office of the police,
Or that hiring of vehicles.
the hiring of vehicles. So here this will come under the service tax.
Lordship, that is added in the GST 5% has already been added in the bill, Lord.
Huh?
Kindly have a look.
It's GST is being given, na?
Yes, Lord. Page 25 for a Gannet paper.
Because nowadays I've been passing orders wherever they are admitting it,
Lordship.
after making those necessary statutory deductions. Because these will be deductions which have to be made at that point of time.
In GST, my lord, so far as GST is concerned, my lord, it is the state, my lord, who will have to, my lord, pay the GST.
Yeah.
In earlier VAT, my lord, it is inclusive in the rate itself. So now, my lord, GST, my lord, they will have to quote the rate without GST. GST will be, my lord, paid by the.
No, therefore they are putting the rate, they are putting it and they are also putting the GST
My lord.
as well as the CGST, page 57 if you see.
Lordship.
So they are putting the GST.
That the authority will ascertain, my lord. It may not be the proper, my lord, the percentage, my lord.
Hmm?
It may not be the proper percentage, my lord, that has been, my lord, fixed by the authority, by the, my lord, petitioner. This is his bill.
But they are putting it at 5%.
Yes, 2.5, 5%.
Issue notice making it returnable on 17th of November 2025. Why you are making this BTC a party?
Lordship, it is under Sirang district a lot.
Huh?
The Superintendent of Police, Sirang district BTA. as well. Respond number.
Police is under the BTC.
But submitted the bill to SPA, so it has no role.
The police is also being transferred. The home is transferred to BTC.
And like the women political department is the.
What subject, my lord? Women political department is not transfer subject, so.
So then how BTC is involved?
But here, the petitioner submitted the bill to SPA.
SP is different,
Yes, my lord.
but SP would not come within the ambit of BTC.
But generally, my lord, general rule is that the women political department pays the bill in such cases.
No. Why is the BTC required to be made a party here?
My lord, the petitioner has made it, but
Understood. But why should we issue notice? Because I think the payment is to be made by, it is not a transfer subject.
yes, my lord.
So it will be the response number 3, 4, 5, 6, 7.
Yes, my lord, 3, 4, 5,
7, 8.
6, 7. The BTC made.
And why you are making the motor transport officer also? He has also requisition.
Lordship, MPO is the vehicle was hired through the MPO, Lordship, as per order of the district commissioner.
But who is to pay?
Lordship, that is paid by the Superintendent of Police, Lord.
So why should we issue notice to response number 2? Not necessary, no?
Lord.
Yes, my lord. It made.
It's not a transfer
Yes, my lord.
subject.
Yes, my lord.
Issue notice to the response number 1, 3, 4, 5, 6, 7, and 8. Mr.
Lordship.
appears accepts notice on behalf of the said respondents. Extra copies be furnished upon him within 3 days. This court, taking into account the dispute, is not inclined to issue notice upon the respondent number 2. The case of the petitioner herein is that the superintendent of police, that the case of the petitioner herein is that the petitioner is the registered owner of 4 vehicles bearing registration number AS16AC 0574, AS16F 9264, AS16G 0944, and AS16C 1019, which were hired by the respondent authorities on various dates during the period from 2020 to 2025. The petitioner have been regularly submitting the bills along with the applicable GST totaling to fees 50,87,378. The said amounts having the petitioner's entitlement having not been paid in spite of various representation, the petitioner has approached this court by filing the petition. The respondents are directed to bring on record their stand by filing the affidavits on or before the next date. Next date to ketia disu? 17/11. 11? Not 9.
7.
Is an option.
What is this?
This is a litigation filed against the non-payment of an contractual amount. The petitioner is a firm, your lordship, who had been discharging contractual works to the maintenance, relating to the maintenance and waste management works of CMCH by virtue of agreement dated 10th of July 2015. Your lordship, till 2017, the petitioners were paid according to the contract, but from 2017 till date, the petitioner is not paid a single penny, your lordship.
So they are demanding some amount.
Spending some amount, your lordship.
From you, how much?
Amounting to 1 crore
19 lakhs,
43,103.
43,000.
Your Lordship, the petitioner already previously approached this Honorable High Court by filing writ petition number 2704 of 2022, Your Lordship.
What are you asking for here?
Your Lordship,
Notice of demand.
notice of demand, yes,
In
Lordship.
continuation with the show cause notice, you are aware that as per the work order dated by the understanding compliance with the demand, confirm the report is a farm demand of one. Now you are challenging this.
Challenging.
Why?
Your Lordship, because the petitioner has not been paid a single penny for their works from 2017 till date. Your Lordship, that's why they
Oh,
have.
they admit that you are entitled to 31 lakhs 26,000.
That's not the actual amount, Your Lordship. 31 lakhs is not the actual amount. The amount, actual amount is the amount claimed by the petitioner. Your
How
Lordship.
much?
43 lakhs. The amount mentioned in the petition, Your Lordship.
How much you are entitled to?
43 lakhs,
43 lakhs.
43 lakhs.
And then
19, sorry, Lordship, 19 lakhs 43,103. Your Lordship, the
one
petitioner,
crore 43 lakhs for 61,600.
the final amount.
That is your amount.
Your Lordship, the amount was increasing, Your Lordship, in every month as they were not being paid.
But madam, how do I issue notice in this? You will go before the civil court.
What is it?
You see what has happened? You claimed 1 crore 43 lakhs and odd. There was a direction in the writ petition, the first writ petition, to make verification and pay. Thereupon you filed a contempt. Then upon verification, they found that you are only entitled to an amount of some 31 lakhs. But they say that they are entitled to around 50 lakhs. And accordingly, they therefore say that they are entitled to 19 lakhs from you. Are these not disputed questions of facts?
Yes,
Why don't you go to the civil court? Now, when the court says that you have to challenge that, and that cannot be decided in a contempt proceeding, that doesn't mean that this court is to exercise the jurisdiction. I think better off you will go to the civil court.
The direction may be given.
Huh?
The direction may be given in the order reflecting. A direction may be given in the order reflecting that.
Ultimately, the calculation, my lord, that order that we have issued on 19/5/25 is not challenged in the my lord, present writ petition.
No, not necessarily. She knows how to do it.
Lord,
I'll give you an indication.
Lord, sir.
Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears, the learned
All the
AG
respondents.
appears on behalf of all the respondents. The grievance of the petitioner in the present writ proceeding is that instead of making payment to the petitioner, an amount of rupees 1,43,61,600 to which the petitioner claims to be entitled to. The respondent authorities, in total disregard to the factual scenario, have held that the petitioner, on the other hand, is to pay to the respondent authorities an amount of rupees 19,43,103 by an order dated 19/5/2025. Next, this court have duly taken note of the materials on record as well as the submissions so made by the learned counsels appearing on behalf of the parties. From the materials on record as well as the submissions so made, it appears that by an order dated 19/7/2024, passed in WPC number 2704/2022, this court disposed of the writ petition, directing the respondent authorities to verify as to whether the petitioner is entitled to an amount of rupees 1,43,61,600. And thereupon, if the petitioner was found to be entitled to the said amount or any part thereof, the same be paid to the petitioner. The respondent authorities, however, did not carry out the necessary verification then, for which the petitioner was constrained to approach this court by filing a contempt proceedings, being contempt case number 651/2024. During the said proceedings, it transpired, during the said proceeding, the counsel who had appeared on behalf of the contemnants have placed before this court an order dated 19/5/2025, whereby it was mentioned that the petitioner was not entitled to any amount. Rather, the respondent department was entitled to an amount of rupees 19,43,103. Taking into account the said contempt proceedings was dropped by an order dated 22/5/2025, giving liberty to the petitioner to assail the said order dated 19/5/2025. This court have also perused the order dated 19/5/2025, whereby, as regards the claim of rupees 2,81,600 per month to the petitioner, the respondent authorities have calculated an amount of rupees 58,850 per month. In addition to that, the respondent authorities have also observed that on account of damages being caused to the STP machines and equipment, there is a recovery to be made from the petitioner to the tune of rupees 50,70,000, and on the basis thereof have arrived at a figure that the petitioner was liable to pay an amount of rupees 19,43,103. This court have duly taken note of that the facts in the instant proceedings, the facts as to whether the petitioner would be entitled to the amount of rupees 2,81,600 per month, as well as to whether the verification have been correctly done or not, and further to that, as to whether the damages for which the respondents have claimed an amount of rupees 50,70,000 falls within the realm of disputed questions of facts, which can only be decided in a proceedings where evidence can be led. Considering the above, this court is not inclined to entertain the instant writ petition. However, grants the liberty to the petitioner to approach the appropriate civil court, appropriate authority, appropriate forum, Is there any arbitration clause? No, na?
No.
Appropriate civil court claiming the amount for redressal of its grievances, comma, the period, no, no, the non-entertaining, the instant order so passed, however, shall not cause any prejudice to the petitioner in the circumstance the petitioner avails appropriate remedies.
Item 8.
Same.
Lord.
Here no BTC, na?
No, with
No.
the Lord.
এই আগৰটো তোৰ order amountটো কিমান আছে ইয়াত তাৰিখকেইখনৰ নম্বৰটো কিমান তাৰিখ এখন দুখন তিনিখন চাৰিখন পাঁচখন নখন তাৰিখ same date 17/11
9.
ইয়াত খালি উচ্চাদা ৰিপিট আগতে আৰ্ট and third. Yes, Mr. Rahman.
May I please, your lordship? This matter relates to my lord, settlement of market, my lord.
Oh. What have they done?
I was the highest bidder, my lord, in respect of the market. That was not done, and the executive officer, she has herself, my lord, settled the matter, market, my lord. That is the,
What is your name?
my name is
Again,
Migan Gogoi, yes, my lord,
Regan Gogoi, you quoted 2,35,000, 23,500.
yes.
There is another one.
The no, they are said it is exorbitant, my lord.
Huh?
They said these two, my lord, Arjun
It has
Tati,
been given to Biman Gogoi
yes,
because he quoted 2,23,000.
2,23,490.
Oh, you missed out by 2 rupees.
Yes, my lord. Because there's a provision, my lord. They have said in the, I mean,
You go as per that particular notification. You look into that notification of procurement by which if it is more than 10%, there may
yes,
be additional.
yes.
Have you enclosed it? Where is that?
That is, my lord.
Well, you have
And I-
not prepared
and I-
your
my lord.
case properly. That is your trump card,
Yes,
and that means your
I have,
entire edifice of your case is not on the basis thereof. Where is your trump card?
that is, they have given, my lord, in the NIT also, and the rules also there, my lord. For 10%, this regarding 10%, this is.
Where is the NIT?
NIT at
What does
page
it say?
20, my lord, that is translated copy. And the 22 is the vernacular, my lord.
Which are the terms you are referring to?
What is, my lord?
Which one?
Page number 21, let's.
In
Yes.
case
12.
of all sworn to the highest tender value submitted, which is within average settlement of last 10 years, plus 10% of the area of the last year. of election. Yes, why have you given it to him?
Lordship, page number 21, 12, NIT, page number 21 and NIT point 12. In case of all market ghat, mean mahal, pound, the highest tender value submitted, which is within average settlement value of the last 3 years, plus 10% of the average settlement value of last 3 years will be accepted for consideration. This is within average 10% average settlement value of the last 3 years plus 10%. But Lordship, in comparative statement, in page number 29, the petitioner is rejected as the bid value offered is higher than 10% of the government value. but this is as per clause 12 within average. And
Madam, what you are submitting reminds me of why P.T. Usha did not get the bronze medal in the 1984 Olympics. She missed out by 100th of a second. Here it is more than that,
more than,
because the difference between
as per
the
clause within
petitioner and the
average.
respondent is above 10% and the
Within-
petitioner is 10.000098%.
So it is more than 10%.
This is
So let's not.
these type of things you cannot do. First of all, your understanding of that is wrong. Here you have to give you a good understanding as regards. You see, what does it mean? In case of, let us read the Assamese version.
Yes, and
Yes. 12.
12 ma'am.
Okolu, Bodha, Dha, Mumina.
At page 24.
So have you
Hello,
taken the
Vit-
average of the last 3 years?
No, that was not like.
You mean the average of the last 3 years plus 10%?
Plus 10%.
Only
Yes.
average of the, but you are mentioning about this 10% on the basis of 10 lakhs, 23,000. This is the fixed rate, government value.
That's it.
Here the 10% would be how much?
Well, I have explained it, paragraph 6, my lord.
223.
Page 7, I have explained.
Hmm?
Rupees 2,23,498. 10%.
7, para 7.
Paragraph 6.
Bid value for so and so, Iman, so and so, so much fixed. The average of Iman is Iman. Above 10% of the Iman of the last year would be 20 lakh. But the total value of the year is 2,25,000. And your petitioner is how much? 2,23,000.
Yes. Yes.
But state. You should notice how long you want a stay to operate.
2 weeks.
Eh?
That's it.
Stay to operate, how long do you want?
That's it. Impugned order was issued on 3rd July 2025.
Has the notice inviting tender been issued?
That's it.
Mr. Roman?
26, 2025.
No, has the
Impugned order issued on 3rd
uh,
July
uh,
25.
settlement order been?
Yes, that has been passed, my lord.
Where is it?
That is, my lord, at
Page number 28.
28, my lord.
Third of July.
Yes.
That's it.
This is given for 1 year, na?
1 year only,
That's
ma'am.
it.
12 months.
Now, if I stay it, what will happen? Who will run the market? You will
Generally, when Anchalik Panchayat will run. Anchalik Panchayat themselves will run.
You will run.
Yes.
That's
Issue notice. Making it returnable. We'll have it next week. Awesome.
2 weeks time.
Yes.
Okay. On 8th of September,
That's it.
issue notice making it returnable on 8th of September 2025. Ms. Enbora, accept notice on behalf of the respondent numbers 1, 2, 4,
1, 2, 5, 7
5,
and 7.
and 7. Mr. S.R. Burwa accepts notice on behalf of the respondent number 3. As regards the respondent numbers 4, 6, and 8. Extra copies be given during the course of the day. As regards the respondent number 4, 6, and 8, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. In addition to that, the petitioner is also directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is agreed by the notification dated 3rd of July 2025, whereby the respondent number 5 had granted settlement in respect to Mathurapur Saptahik Bazar in favor of the respondent number 8. Though,
By the respondent number 7, Mike.
huh?
Executive Officer Lakwa Anchalik Panchayat.
By the respondent number 7 had granted the settlement in favor of the respondent number 8.
Yes.
The respondent number 7 had granted the settlement, have allotted the settlement in respect of Mathurapur Saptahik Bazar in favor of the respondent number 8. Though the petitioner bid was higher than that of the respondent number 8. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the comparative statement enclosed as Annexure 3 to the writ petition. It is seen that the respondent number 6, the petitioner's bid was rupees 2,23,500, whereas the respondent number 8's bid was rupees 2,23,498. This court inquired with Miss N. Bora, the learned standing counsel of the Panchayat PNRD department, as to why the petitioner have been not granted the settlement in spite of the fact that the petitioner's bid was higher. It was pointed out that the petitioner's bid was 10.00098% higher than the bid value, whereas the respondent number 8's bid was only 10% higher. Be that as it may, this court have duly taken note of clause 12 of the notice inviting tender, which stipulates that what is required to be taken into consideration is that the average settlement value of the last 3 years plus 10% of the average settlement value of the last 3 years would be accepted for consideration. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court that the bid value for the year 2022-23, 2023-24, and 2024-25 in respect to the market in question in total was rupees 6,14,520. And as such, the average of the 3 years would be rupees 2,04,840. He therefore submitted that 10% of the average of the last 3 years would be rupees 20,484. And therefore, the total would come to, and therefore, the bid had to be quoted within 2,25,324 as per clause 12 of the NIT. He therefore submitted the consideration on which the petitioner's bid was rejected is completely unfair and amounts to settlement given in favor of the respondent number 8 to favor the said respondent. So this court, having heard the learned counsels and having also perused the materials on the record, is of the opinion that the petitioner has been able to make out a case for passing interim directions. Accordingly, this court, taking into account that the petitioner has been able to make out a case, strong case, on strong case as regards the interpretation to clause 12 of the NIT stays the settlement, the notification dated 3rd of July 2025, by which the respondent number 8 was granted the settlement in respect of Mathurapur Saptahik Bazar for the financial year 2025-26. Till the next date. It is observed that till the next date, the respondent authorities shall run the said market to, what do you say?
To their official arrangement to the.
To the Anchalik Panchayat.
Yes, Anchalik Panchayat.
Lordship,
Lakwa Anchalik Panchayat.
Huh?
Lakwa
Lakwa
Anchalik
Anchalik-
Panchayat, this
to the
one is
Lakwa
Lakwa Anchalik
Anchalik.
Panchayat. We didn't.
On payment.
Lordship, work order is of 2012, Your Lordship. And he approached in 2025 and no explanation for delay, Your Lordship.
Reason for delay does not arise, but the question, how will these people find out?
Lots of covered case already, 13/8/2025 filed. More than about 40 matters are already disposed of.
Huh?
This, yes. Covered case, Lordship.
Oh, that is different. That was the judgment passed a long time back. Tell me, how will these people find out the documents?
Yes.
Not a single representation also.
But the petitioner approached the authority, but authority denied to take it.
Not a single representation also. Nothing is there. How do I help it? You do go submit a representation and see what happens. Then I give you a liberty to appear. Approach. First submit a representation.
Lordship, earlier, some other cases, the same, question arise. Lordship. Same question was arise earlier regarding the water research department. Many cases like that. They also approached the.
Matters are pending.
No, Lordship. That's already disposed of on 13/8.
But how do I know that these are pertaining to those years?
Lordship, I have also many requisition there.
You belong to which scheme?
Water Research Department, Water Research Division, Morigaon.
Which scheme?
Lordship, RS 2T died along both banks of Kopili River from Sorahagi to Tuklai to Bosundari to.
Under
Kit-
what
Junction.
scheme? There are 4 schemes referred to. How will these people verify? Tell me. Last payment was made of 1,55,000. When?
Lordship, it was one. There are 3 installment, Lordship. One installment is 61,000. That was one.
Bill, sir, of Lordship of.
I think you go to division bench. I dismiss your petition on delay. Sorry. I'm going. Heard Mr.
Yeah, long.
And so the legal counsel appearing on behalf of the petitioner. Ms. Ardeka appears on behalf of the Water Resource Department of the government concerned. You? Ms. So-and-so appears on behalf of the respondent number 7. Union of India? None appears on behalf of the Union of India on call. The petitioner has approached this court seeking a writ in the nature of mandamus directing the respondent authorities to release the outstanding balance amount of rupees 3,07,274, which the petitioner claims to be entitled to. It is relevant to take note of from the materials on record that the petitioner was issued a work order on 15/9/2012 by the Executive Engineer, Morigaon Water Resource Division, Morigaon. It is the case of the petitioner that pursuant to the work being completed, out of the total bill amount of rupees 4,62,597, an amount of rupees 1,55,323 was paid, and the remaining amount of rupees 3,07,274, however, remains outstanding. It is relevant to observe that the said bill, there is no mention in the petition as to when the amount of rupees 1,55,323 was paid to the petitioner. It is also pertinent to observe that there is not also any representation submitted by the petitioner before the authorities concerned seeking payment. Under such circumstances, it is therefore the opinion of this court that a delayed claim is sought to be agitated by filing of a writ petition before this court, that too without approaching the authorities concerned. Considering the above, as the petitioner have not approached the authorities concerned, and The writ petition do not explain any delay or latches. The instant writ petition. This court is not inclined to entertain the instant writ petition for which the writ petition stands dismissed.
11,
However, is given to the petitioner to approach the appropriate authorities if so advised. Yes, Mr.
this matter relates to the non-payment of the bill. It is being admitted by them that is page 14, your lordship will get the picture, annexure A. The amount they have already out of 31,41,346. The department has paid 16,95,005 and outstanding is 14,46,341. Page 14.
Only thing is, Lordship, the petitioner has not annexed the work order here, Lordship.
You have admitted it on as per the RTI. I have given the particulars of the work, bill number.
Mr. Biswas, tell me, you are asking for a writ
Yes.
directing them to pay the admitted liability. The admitted liability has to be normally done by the chief engineer.
Yes.
This is not being done by anybody else except some executive engineer or the accounts officer.
Lordship.
Okay. So, can you, without the work orders out here being brought on record, where you are entitled to how much you have been paid, all these details having not been providely
I will
given,
annex the work order. I will bring it.
what to do?
Give me a little time and bring it.
You want to file an additional affidavit?
I have to find it then.
The counsel appearing on behalf of the petitioner seeks 2 weeks' time to file an additional affidavit bringing on record the work orders as well as necessary pleadings in support thereof to claim that the petitioner is entitled to the amount. This is the matter of the case.
12,
Lord, on last occasion, we withdrew the petition, my lord. Liberty was given. Now we have brought on record, my lord, the two orders.
Yes.
My lord, if your lordship would kindly come to page 31. This second point, my lord. In it will be given to the operating agency initially for a period of 5 years, which is automatically extendable for another 5 years on the basis of satisfactory performance as per mutually agreed terms and conditions. In such a case, the operating agency has to make a formal request to the PIA 3 months in advance of the expiry of the contract. So, my lord, we have made, my lord, but they've not rejected either, my lord, but they have issued a retender. My lord. Initially, they issued the first order on, my lord, 27.
But how do you apply that condition, taking into account that you made the request only on 19/7/2023?
Yes, yes.
Whereas you had to do it prior to 3 months.
No, my lord, that aspect was not taken note of. In fact, page number, my lord, 37, they have asked the authority to process it. If your lordship would kindly come to page 37. MD, na? MD question.
Who has
On
done
top,
it?
on top, there is an endorsement, please process by the
The-
managing director, my lord.
This is whose signature?
Managing director, na?
Where do I
K.
know?
Kumar will deal. Well, I think it is by Pranab Jyoti Talukdar. No. Sorry, Pranab Jyoti is the, my lord, applicant. Look, towards the bottom of page 37, there is a seal also. It has not come out very prominently, not legible very. But the competent authority has directed that it should be processed. That is why, my lord, till basically 28/5/25,
We were, sorry, 5/8/25, we are there.
Where is the termination letter?
There is no termination order has been issued.
There is a termination.
No, first one is that,
Yeah, this one, 15/7/2023.
Yes.
You were given prior to that, thereafter you submitted this document.
yes.
You have been earlier terminated.
No, my lord, the termination on that ground, they have not rejected, my lord. They in fact processed my thing. And I continued, and even today I'm possessing, my lord.
No, we can issue a notice. Issue notice returnable on. Artfed is not represented.
No, my lord, they will have to, we'll serve them, my lord. We can do by Dusty also.
Notice making it returnable on. Can you do it by 15th?
Yes, my lord.
15th of
In fact, tomorrow itself we'll serve the copy.
15th of September 2025.
Hello.
Mr. Ardhar appears on behalf of the.
Response number 1 and 2,
One and two.
1 and 2, my lord.
1 and 2. Extra copies be served upon him during the course of the day. As regards the respondent number 3, the petitioner is directed to take steps by way of registered as well as usual. In addition to that, the petitioner is given the liberty to take steps upon the respondent number 3 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner hearing is that the petitioner hearing is aggrieved by the action of the respondent number 3 in initiating steps for use of the facility.
Tender is in respect of 1, 2, 3. Lord, tender is in respect of 3 units, but we are concerned only with unit number 3.
Agreed by the action on the part of the respondent number 3 in issuance of the notice inviting tender dated 29/7/2025, whereby the respondent number 3 is taking steps for use of the facility in apparel and garment making center. Where?
Boragaon, my lord.
At Kochim Boragaon.
Yes.
Kochim Boragaon. The case of the petitioner herein is that a memorandum of agreement was entered into between the respondent number 3 and the petitioner on 1st of July 2018 for a period of 5 years. In respect to the respect to
1500 plus square meter.
in respect to the running of 3 unit, the Roman 3 unit of apparel and garment making center at Kochim Boragaon, Guwahati,
Square feet.
under the Northeastern Textile Promotion Scheme of the Government of India. Full stop. It is the case of the petitioner that the agreement, though initially was for a period of 5 years, but would be automatically extendable for another period of 5 years on the basis of satisfactory performance as per mutually agreed terms and conditions. The petitioner further states that on 19/7/2023, the petitioner duly submitted the renewal of the lease agreement for Unit 3 of the Apparel and Garment Manufacturing Center at Kochim Boragaon, which was duly accepted. However, and the petitioner thereupon was allowed to continue till a communication was issued on 18/2/2025, directing the petitioner to vacate the unit within 30 days. Thereafter, the petitioner submitted a representation on 28/5/2025 to reconsider the decision of terminating the lease agreement midway and allow the lease agreement to run its course in 2008 to 2028 and rescind her. It is the petitioner is further agreed by the notice inviting tender dated 29/7/2025, where the said unit which was allowed to be run by the petitioner had been put to in the tender process. Full stop. Mr. K. N. Chaudhary, the Lalic Senior Counsel, appearing on behalf of the petitioner, submitted that on the basis of the said notice on the basis of the agreement dated 1st of July 2018, the petitioner had made necessary various investments, and as such, the said amount, the said investment, and was also entitled to the automatic renewal. He further submitted that although by the communication dated 15/7/2023, there was a direction that it was mentioned that there was a termination of the said agreement, but subsequent to the communication submitted on 19/7/2023 and the regular acceptance of the rent, it can be implied that the respondent authorities have categorically extended the period and therefore was entitled to running of the unit till 2028 as per the terms of the agreement. Yes, Mr. Dardhor, what do you have to say?
My lord, regarding that acceptance of the rent, my lord. My lord, I have gone through the documents. My lord, this is
The learned senior counsel further submitted that the notice inviting tender insofar as the unit which is being run by the petitioner should not be allowed to be processed, inviting tender dated 29/7/2025, insofar as the unit which is the petitioner is running at Kochim Boragaon should not be allowed to be processed till the disposal of the petition. Yes, Mr. Ardhor, what do you have to submit?
my lord, the first thing is that regarding that rent, my lord. My lord will come to page number 39, 40, 41. These are three documents, my lord. These are transactions, my lord, the petitioner has done through bank, my lord. So it is not that we have not, I am though not representing this Artfed, my lord. I can say that, my lord, this was deposited in the bank account of the my lord Artfed, meaning thereby it is not that they have my lord accepted it. Anybody can, my lord, deposit if they have an account, my lord. First thing, my lord. So that part will, my lord, will examine. Second is, my lord, I think petitioner is little late to come before this court, my lord. 19/7/23, my lord. They knew about the thing, my lord. They wrote a letter to the authority, Artfed. Nothing happened, my lord. They did not get any communication from the authority, my lord. So they should have approached this honorable court, but they did not so, my lord. In the meantime, in 25, Artfed has, my lord, already communicated that you vacate it within a period of 1 month. So I think they are late to come before this court. And the bigger thing is, my lord, page 50. My lord will see 50, page 50. There are 3 units. In tender, my lord, the basic minimum rate Artfed has quoted is rupees 10. 15,000 square feet, my lord. In a city like Guwahati, 10 rupees is the basic price, my lord, rate Artfed is, my lord, quoted. 15,000 means 1,50,000, my lord. Whereas the writ petitioner was in possession of that, running that business at 50,000, 51,000, my lord. So, my lord, this is ultimately, this money will go to the exchequer, my lord. Whatever, this will become public money. So, my lord, that aspect also we have to look into. Why the Artfed has, my lord, has gone for a tender. Because, my lord, this money will, there will be, my lord, bidding. People will come and quote, my lord. So, basic is 150, they are sure to get. Maybe even bidders may quote for higher price also. So, my lord, that aspect also, my lord, why the Artfeds, they are also running at loss on granting aid, they are somehow managing. So they also need, my lord, some financial sources to earn and continue their thing, my lord. So they have taken a stand that we will go for a transparent bidding. Whoever gets it, my lord, even he's also, my lord, he also can participate. It is not that he is barred. He can also participate.
So you mean to say that if the Artfed, if there is an agreement also in existence, the Artfed, in order to get more money,
No, my lord.
can violate the terms
No,
of
my
the
that
agreement and go for a
agreement has already ceased. To my understanding, my lord, the agreement has already ceased. They have issued a termination order, my lord. After a span of that, with lapse of time, my lord. Well,
Let me note down.
my lord, my lord.
Mr. Ardo, the learned counsel appearing on behalf of the respondent number 1 and 2 submitted that though he is not representing the respondent number 3, but from a perusal of the agreement dated 1/7/2018, it would be seen that the right to have an automatic automatic renewal for a further period of 5 years was subject to making a request within 3 months, prior to 3 months from the date of expiry of the agreement. He submitted that the agreement would come to an end on 30/6/2023. However, there was no request so made. It was only on 15/7 the learned counsel therefore submitted that on 15/7/2023, taking into account that there was no request so made, the managing director of the respondent number 3 had terminated the said agreement on the said condition. The learned counsel hearing for the respondent number 1 and 2 further submitted that there is no challenge to the said document. Rather, the petitioner applied for a renewal on 19/7/2023, and there is nothing on record to show that any fresh agreement was entered into by and between the petitioner and the respondent number 3. He further submitted that thereupon the petitioner was asked to vacate on 18/2/2025, and the petitioner then also did not challenge the same, and it is only after the issuance of the notice inviting tender that the petitioner has approached this court by filing the present writ petition. He therefore submitted that the instant writ petition is not only a delayed writ petition, but the question of the petitioner getting any not only had been filed, he suffers from delay and latches, but also the petitioner does not have a cause of action to challenge the notice inviting tender in as much as the agreement between the petitioner and the respondent number 3 have ceased to exist since 2023. This could have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The materials on record, more particularly the clause on which the petitioner seeks that there would be an automatic extension, is subject to the petitioner requesting for making a formal request to the PIA. What is the PIA business?
Project Implementation Authority.
Huh?
Project Implementation Authority.
To the Project Implementation Authority within prior to 3 months from the date of the expiry of the contract period. The said aspect, however, have not been done admittedly was not done by the petitioner. And it is and resultantly on 15/7/2023, the managing director of the Artfed have categorically observed in the communication that for not doing so, the agreement was terminated. The agreement was the agreement to MOU was terminated. This court further takes note of that on 19/7/2023, the petitioner had submitted a communication to the managing director of Artfed seeking extension for another period of 5 years. And with a request to renew the lease agreement. There is nothing mentioned. And it is pertinent to observe that there was no renewal of the lease agreement. On the other hand, on 18/2/2025, the petitioner was asked to vacate the premises within 30 days. The resultant effect thereupon was that the notice inviting tender was issued on 29/7/2025. This court, having taken into account the materials on record, do not find that the petitioner has been able to make out a case for grant of interim directions for stay of the notice inviting tender dated 29/7/2025 insofar as the Posim Boragao unit of the respondent number 3. However, this court observes that the petitioner herein shall be at liberty to participate in the said notice inviting tender, in the said tender process without prejudice to the rights and contentions in the present writ petition. This court further observes that any decisions so taken in pursuance to the notice inviting tender shall be subject to the outcome of the writ petition.
Deep level.
Item 13. Order implement of party.
Yeah, please, your lordship.
Yes, whom do you want?
Lordship, Nikon Power and Infra, lordship.
Huh?
Nikon Power and Infra, lordship.
Nikon
Nikon, lordship.
and executive director.
Yes, lordship.
Why?
Lordship, actually, the matter here at hand is, lordship, this. I am an MSME. I had supplied electrical goods to the respondent via Nikon. But lordship, the thing here is that the goods were approved and they were, taken over by Power Grid, the respondent number 1 and 2. And they also made direct payments. to me.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, applicant and applicant of the petitioner.
Respondent one
and
and two.
Mr.
Respondent number 1 and 2.
So-and-so
Team
appears on behalf of the respondent number 1. The petitioner herein submits that
My
the
lord, if I
petitioner herein, who is the applicant, had filed the instant application seeking improvement of the opposite party number. The respondent numbers 1 and 2 of the instant application to the accompanying writ petition. On the ground that the petitioner made supplies to Power Grid Corporation.
My lord,
Limited.
if I can clear some clarification, my lord.
Huh?
What had happened is that, my lord, Ms. Nikon, I have awarded the contract work to Nikon.
It's the council. He says,
Yes, my lord.
he submits,
Oh,
you supplied to Power Grid through Nikon, isn't it?
Yes, Lord.
To the respondent number 1. Respondent number 1. To the respondent number 1 of the writ petition. To the respondent numbers 1 and 2 in the accompanying, in the present application. He therefore submits that the said respondent numbers 1 and 2 of the instant application be arrayed as respondent numbers 3 and 4 to the accompanying writ petition. You know,
No objection.
the council appearing on behalf of the you have to appear for 1 and 2. Why
Yes,
are you
sir.
appearing for 1?
1 and 2, my lord.
1 and 2, appears for 1 and 2. The learned counsel the learned counsel who appears for the respondent number 1 and 2 submits that he has no objection to the instant application. Taking into account the above, the instant application stands allowed, thereby arraying the respondent numbers 1 and 2 in the instant application as respondent numbers 3 and 4 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis thereof, within 7 days. And the registry shall, on the basis thereof, shall make necessary changes in the cost title as well as also update the same in the CIS. Instance disposed, our main petition issue notice upon the newly included respondent numbers 3 and 4. Steps be taken by way of registered as well as usual. Notice returnable on 1st of December 2025.
Highly obliged.
Item 14.
Made with your lordship. What is this? Lordship, it is an IA for implement, your lordship.
Implement of whom?
Implement of the new deputy commissioner, district commissioner, as well as the circle officer and the commissioner, your lordship.
Contempt.
Contempt, your lordship.
This is an application filed by the petitioner seeking implement. The filed by the applicant seeking implement of the present officials who would now be responsible for the purpose of implementing the order dated
7/11/2017, your lord.
7/11/2013,
2017.
2017.
17.
Where is that?
Lordship, it has been annexed as Annexure A in page number 12.
7/11/2017
17.
in WPC number
In WPC number, your lordship, 206 of 2015
206.
of 2015.
Of 2015. Taking into account the said aspect, this court is of the opinion that the said respondents, the said opposite parties. Numbers,
4, 5, and 6, Your Lordship.
opposite party numbers 4, 5, and 6 be arrayed as respondents in numbers.
Lordship, they would also be 4, 5, and 6 in the writ petition, I believe.
You want the substitution? Or no?
Lordship, the
They will
previous,
be opposite parties as respondent numbers 4, 5, and 6 in the contempt application. The petitioner is directed to file fresh memo of parties before the registry and retaliatory within 7 days. Huh? Now tell me, what have you done? What is the dispute?
Lordship, the dispute relates
What
to,
is the direction given?
Lordship, the direction was given for the respondent authorities.
Considering the matter and taken time that when taken for the grant of mutation and issuance of patta, this court feels that the direction be issued to respond to take up the matter earlier, examine the same and pass necessary speaking on. Which deputy commissioner is it?
Lordship,
Yes, madam, what is wrong? Why the deputy commissioner is not being able to deal with the mutation order? What is wrong?
Lordship. Potato Kamrup Metro. My lord,
We have it next week, let me come back.
my lord,
Let me have it on 8.
eight.
We asked the deputy commissioner, there was a direction. What is the direction? Kindly see from the contempt petition.
Lordship,
Considering the matter on the record and the time spent taken for granting mutation and issuance of patta thereof, this court feels that a direction be issued to the respondent to take up the matter at the earliest and to examine the same and pass necessary speaking orders under the provisions of law. Whole exercise be completed. Now you are required to pass an order.
Lordship.
What is wrong? Does it take
I'll-
from 2015 onwards?
My lord, I'll take instruction, my lord, that.
If I was the person concerned, I would not filing of this. It should have been the order has be passed.
My lord, my lord.
এখন দিও মেইন করুন ইস্যু নোটিস মালা এখন তো দিল এখন মেইন কোন this court duly takes note of that by an order passed by this court on 7/11/2017 in WPC number 206/2015 a direction was issued to the respondent numbers 1, 2, and 3 and more particularly to the respondent numbers 2 and 3 to dispose of the mutation proceedings by passing of dispose of the mutation proceedings as well as the issuance of patta within the time frame of 3 months. Full stop. 8 years have passed by and the said order have not yet been complied with. Ms. Yudas, the learned senior government advocate, additional senior government advocate, shall apprise this court on the next day as to why the order dated 7/11/2017 in contempt in WPC number 206/2015 have not yet been complied with. Full stop. This court further directs, gives the directs the petitioner to serve, to effect service upon the respondent numbers 4, the newly implemented respondent numbers 4, 5. Why do you need the revenue department? Not necessarily. Respondent numbers 5 and 6. 4, 5, and 6. By way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. List the matter again on 15th of September 2025. A copy of the contempt petition is served upon Ms. Yudas, the learned additional senior government advocate, for obtaining instructions as regards the non-compliance.
of the list.
My lord,
How much time?
from the industries department, I have taken the instructions. Within 7 working days, they will send back the file to the labor department.
This matter on 8th of September at the top of the list. In the meantime, as submitted by Mr. Dina, has been. This court hopes that the Industries Department provides the necessary inputs for the finalization of the draft standing order.
Lordship.
Item 32, fixed at 2 p.m.
My lord, 32 and 34, that may be taken after some time, my lord. I have received the instruction, my lord. My junior is about to print out, my lord. Pairwise instruction I have received in both the cases, my lord.
Yes, why have you gone for this new one?
My lord, sometime, after some time, my lord.
Oh, you have cancelled it, no?
Yes, two cases are there, my lord.
You have cancelled it for the reason you have shown it in the minutes.
My lord.
The minutes does not show the good reasons.
My lord.
On 24th.
Yes, my lord. Or lordship may fix a short date, my lord. I'll file affidavit in both cases, my lord.
We have, no, I'll pass this. It is, you have participated
Yes.
The next one, your lordship, no, I have not participated.
in this one?
The first one, your lordship, the petitioner, he had submitted.
Now, in this case, you have participated, no?
yes.
Now, I have allowed it, no? Participation of the petitioner
Yes,
in the
no, no,
tender
in
will
the
shall
last-
not cause any prejudice
Yes.
to the present. Yeah, you have participated.
No, no.
Huh?
But in terms of that order, your lordship, the petitioner could not participate here.
Why?
Shortage of time, your lordship.
Mr. S. Doctor, the learned standing counsel of the PNRD submits that he has received the instructions and will be filing the affidavit within 7 days.
My lord. My lord.
Within 7 days. Taking into account the above, list this matter on 8th of September 2025. Liberty given to the petitioner to file reply, the affidavit be filed by 1st of September.
My lord, I'll file earlier, my lord. Short time may be given because revenue is also important matter, my lord.
Huh?
And generating the revenue is also important, my lord.
Therefore, let me set aside now.
Short,
Matter over. Give it to him.
1 week only, my lord.
He'll get the price. They're already getting the amount. He is quoting a high amount. What is wrong?
My lord,
Unless it is some blue-eyed person you want
No,
to
no,
take it,
no.
he has not come in.
no, my lord.
Yeah,
That-
then otherwise there's no good reason. As I saw it in the minutes which have been recorded. Is it?
Lord, next week, my lord, any date may be possible. If possible, my.
Submits that within a week's time, he will be going to file an affidavit to stop. The affidavit be filed by on or before 26th of August 2025.
My lord.
Liberty given to the petitioner to file reply by 2nd of September. List the matter on 4th of September 2025.
My lord.
5th of September 2025. Interim order passed earlier shall continue till then.
My lord.
In item 35.
No, 32 and 35 same, my lord.
35 also same.
Same.
There's an interim order there?
Yes.
Yes, my lord. Similar. All right. I'll list.
For admission, item 16.
May I please, your lordship? Lordship, may kindly allow 2 weeks time for filing one IA, lordship, IA for improvement of party.
Cost given,
Yes, lordship.
good. Now this is for non-payment.
Yes, your lordship.
Yes, what is your affidavit?
We have already filed our affidavit in opposition.
After verification of work done by the petitioner, it is found the petitioner executed only value of work of the man in the split. That on February, the engineer prepared the bill and submitted the report. That with regard to the statement they have done, it has been supervised by everyone. That the submission of demand for the fund and disbursement of the amount of question by the demand concern. The executive engineer has already submitted the question of funds to the development. Already been done. So he's entitled to amount of 77 lakhs 60,000.
Yes, Your Lordship.
But our claim is 1 crore 1 lakhs 49,700. Lordship, who did not make the party revenue department. Lordship kindly allowed 2 weeks time for filing one IA for implement of party.
Implement of whom?
Revenue department, Lordship.
Revenue is not a party.
No, Lordship, one order 29/5/2025, Lordship. Kindly peruse this order. Revenue department is in. We did not make a party, Lordship. So kindly allow some time for filing IA.
The council appearing on behalf of the petitioner submits that some time may be granted for filing an appropriate application for including the revenue department of the government of Assam as a party to the instant proceedings. Pusto. Taking into account the stand now, tell me, deputy commissioner is already a party. Why you are not making the payment? Yes, she has nothing to do with the deputy commissioner, the revenue department. You issue a tender and it is being worked through the PWD. Is PWD or water resource?
Water resource, Lordship.
Water resource.
Resource.
Department. Water resource department categorically says that she is entitled to the 77 lakhs or something. Why you are not making the payment?
Lordship,
And why, sir, why do you trouble the petitioner of making this party, that party and whatnot? We are not concerned with that. Why haven't you filed an affidavit?
In the order dated 29/5, Lordship.
Why haven't you filed an affidavit? Why?
Lordship, old matter, we have to take instruction, Lordship.
Whole
Brief-
matter, the
brief is-
matter has not come up for the
brief
first
is-
time.
Lordship, brief is somehow misplaced, Lordship. We will take categorical instruction on that, Lordship.
You file your affidavit, don't
Lord.
make the party.
Lordship. And may I ask for a copy of Lordship?
What copy? There is no copy to be given. You pay amount, then you get a copy extra. You don't get copies like this.
Lordship.
Why will they give you copy, keep on giving you copies? You have
Lord.
given copies, you are very much present.
Lord.
This type of, whatever happens, you have separate set of councils appearing separate time. Can't happen like. Pay them requisite cost. Per page 1,000 rupees.
We get it.
You do it, right? This court duly takes note of that the petitioner, though had claimed an amount of rupees 1 crore 1 lakh 49,077. But the affidavit so filed on behalf of the Chief Engineer, Water Resource Department certifies that the petitioner had executed work of the value of rupees 77 lakhs 60,908.94 in the stipulated scheme. It is further mentioned by the affidavit so filed on behalf of the Water Resource Department that the said payment has to be routed through the Deputy Commissioner Karimganj as the said authority is the concerned authority. And and as such, necessary requisition have also been made to the Deputy Commissioner Karimganj. This court duly further takes note of that in spite of notice being issued way back in the year 2020, there is no stand taken by the Deputy Commissioner as to why the payment have not been made in favor of the petitioner to the extent which have been duly admitted by the Water Resource Department. That is rupees 77,60,908.94. List the matter again on 10th of September 2025, the Deputy Commissioner Karimganj, the District Commissioner Karimganj, who is the respondent number 6 herein, is directed to bring on record its stand by filing the affidavit on or before 8th of September 2025. Failure to do so, this court shall be constrained to pass appropriate orders.
Lordship, may I ask for a copy of this order, Lordship?
Why?
Lordship, I'll get it downloaded.
Okay.
Lordship. Obliged.
Item 18 and 19.
17 has been withdrawn, I'm told.
Withdrawn. It was not informed.
17 has been withdrawn, no? 15 and 17 has been withdrawn.
Withdrawn.
Yes, what is this?
Well, the losses, previous order is there, my lord. Losses fixed. Now we can file the affidavit.
Affidavit filed
Well, and power purchase.
Affidavit has been filed
regarding
on the issue of interpretation of the rules and the.
that one,
Yes.
FPPA.
Yeah,
Fuel
yeah,
and
FPPA.
purchase or.
How do you explain it?
5.5, that is.
So you want to file reply?
My lord, I don't think, my lord, reply is necessary, my lord. Yeah.
That, now tell me.
My lord. My lord, if your lordship see, my lord, that the notification is at page 23, my lord. The main portion is at page 27 onwards.
23.
Yes.
In fact, this holds the field.
My lord,
The draft notification has not come.
no, that has not.
That has,
So
it was
this
notified.
holds the field 2012.
This is the only notification, my lord.
Now this is the fuel power
think-
purchase
no.
price adjustment formula.
Yes.
What does it mean? What
My
do
lord,
they
this is
do?
the main clause is the 5.5 at page 28.
5.5.
Yes.
Now what is this fuel power purchase price adjustment?
Adjustment.
Concept is what?
Concept, my lord, they purchase some fuel, my lord, and power from other manufacturer, my lord, who produce power, my lord. And at higher price, my lord, so they want to, my lord,
So this is a fluctuating thing
fluctuate
and it is done quarterly.
quarterly.
This adjustment is made quarterly.
Yes. That-
Based upon what amount is being spent on
Yes.
the fuel
Fine.
purchase.
Yes.
So it is being done quarterly,
Quarterly.
It is to be calculated quarterly, billed monthly,
billed monthly. but
billed monthly, but calculated quarterly.
Okay, give me an example.
So the control period, because your lordship, the fuel prices keep changing every day, your lordship, but that would lead to a extraordinary situation that we cannot. So what the commission in its wisdom determined was to take a control period of a quarter, 3 months, apply the formula to that quarter, then you come up with the rate at which the FPPA, the fuel purchase is to be applied to the bill. But the amount, it's to be added to every monthly bill which is generated. That's what the regulation says.
See that this is based upon you purchase fuel.
Yes,
for the purpose of generating power.
generating power,
Now, the price of fuel keeps on changing.
Lordship.
So what the APDCL or these authorities have done is, they have put it as a bracket of 3 months.
3 months.
So every 3 months, there will be a change.
There will be a change
Depending upon what change, what's amount have been spent
spent,
on purchasing of the,
Lordship.
that's the
Lordship.
concept.
Yes,
Now, for the, let's take example for the month of January to February, March.
March.
This is the quarter.
This is a quarter.
quarter. So this period, how much amount is being spent in the fuel has to be applied at the end of the quarter?
At
They
the
will
end,
know
from
only at
the,
the end of the quarter
it
or
will ha-
prior,
it will be from April,
from April?
from April.
From April. So what amount have been spent out there in the fuel? It is being then adjusted and taking into account the consumer index. They divide or subtract whatever may
Yes,
be.
depending-
And then put it so the amount is being put out to that, to each consumer has to bear a burden on that amount,
Lordship.
which is on touching on the fuel expenses being incurred.
Because in a way, he has already got the benefit for that period.
He has got the.
He has got the benefit.
He has got the benefit, but you only take once it is being spent.
Yes,
After 3 months, you make that.
we make that.
Now, what is the case? This is the.
Now the case is this, my lord. If your lordship will see the
9.5.
clause, my lord, clause 5.5 at page
Each
58.
control period shall be a quarter of 3 months.
3 months.
Accordingly, distribution licenses shall compute and adjust the amount as per so and so. Thus, FER charges for the quarter shall be charged from the first month of the next quarter.
Next quarter.
So therefore, from January to March,
Yes.
it will be done from April 1st to June 30th.
June.
So there will be a same FPPA
Yes.
for June.
Yes,
Yes.
April to June.
April.
My lord, here, my lord, notification is there, my lord, that a notice is issued on page 31.
Page
31.
Yes.
So this notice is issued, my lord, electricity consumers, sense of fuel purchase price regulation.
For the next.
For the levied with the respective category of consumer for next 3 months, effect from June, so and so until further order. Energy consumed in May. My lord, they are giving, my lord, have to speak effect. My lord, it should be given from July onwards.
But June also you have to pay FPPA.
No, June, no, my lord, the quarter, my lord, starts from July.
Understood, but earlier to that also there must have been some amount spent.
Yes, yes.
on FPPA.
that-
Because FPPA is from 2012.
My lord.
So therefore, for month of June, you may have to pay. some
Might have, my lord, that is another earlier notice.
earlier.
As per earlier.
So what is the increase now?
Now, this notice is, my lord, given effect from May onwards. It is issued on 27th May 23 and
No,
this
it has
charge,
been given effect from June onwards.
my lord,
It has been given effect from June onwards.
no, energy consumed during May also 23.
No, there cannot be actually, you see, if we take the quarters,
Yes,
January to March, April to June,
yes.
so it has been from month of July.
July, yes, that should be from July. That is my case, my lord. That this notice cannot be given in such a manner that it will give retrospective effect. So it should.
So what was the existing then?
Well-
What was the FPPA prior to this?
Well, that is not here, my lord.
Because you are paying some amount.
Yes,
There is a regular consumption.
yes.
So there must be regular spending on, there must be a regular.
No,
FPPA.
that whatever is there, my lord, that they are paying. But here, so far, this notice is concerned. My question is this notice can be given effective from July onward. Not,
But what do you have to, but you have to pay for month of June.
no, June, my lord.
Why?
Because quarter,
When did you have your business started?
no, business is going on, my lord, from,
So therefore, you have to pay FPPA
yes. My
for
lord,
the month of June also.
for
you
the
have to
earlier
pay.
period, my lord, that is for, from the
Understood. Is it that is there a double charge? I'm
Yes.
asking you there.
Yes.
Is there a double charge of FPPA
Yes.
in the month of June? On account of two notifications going together? I'm asking you that. Otherwise, no.
It is, my lord.
Mr. Pathak,
Lordship,
every month he has to pay.
every month he has to.
So FPPA will remain there.
It is-
Maybe the factor may change.
Yes.
Amount which will be 0.30 per kilowatt could have been 0.029 or 0.31 also. It will keep on
It will
changing.
keep on changing.
But the question is, if, for example, you have by this notification, which may be wrong also. It should have been done from the month of July
Or from the month of April.
or from the month of April.
Yes.
You could have done it if you are fixing it. But the fact remains that he has to pay for the month of June, as well as for July, as well as for April, everything. The only factor would be the difference in per kilowatt.
Yes.
But the question of not paying FPPA does not
Does not.
arise.
Now, if I may just explain, Your Lordship, what has led to this notification. There are some facts which might be relevant. So we have brought on record a tariff order which is passed by the AARC. So the AARC issued a tariff order dated 29 March 2023, where it was a true up for the previous financial year of 2021-2022. There, as per the tariff schedule, it was stated that the tariff which is determined by the AARC is inclusive of FPPA. So now this led to a situation where APDCL was not sure that whether they could independently now levy the FPPA or not, because the tariff determined by the AARC says that it is inclusive of the price adjustment.
Price?
The FPPA, the price adjustment, the fuel and power purchase price adjustment, it's inclusive of the price adjustment. So in that situation, we communicated with the AARC saying that since you have said that this is inclusive, how now should we levy the price adjustment or not? So the AARC said that yes, we can levy it. What has happened in this case, if Your Lordship has the notification at page number 31,
31.
we have made a categorical stand. We have taken a categorical stand in the affidavit that the control period is January, February, and March. It should have been levied from April. But we have in fact given a deferment of 1 month, Your Lordship. Instead of the month of April, it comes into operation from the month of May. So that is why, because there was an ambiguity, because of the issuance of the previous tariff order, there was a deferment of a month. Perhaps what may fall for Your Lordship's determination and what perhaps there may be a procedural error by APDCL or not is that it was only supposed to run for three months. So it should have run from April, May, and June. What they have done in the APDCL is they assume that it's supposed to run for 3 months. So instead of ending this at April and May, in June, they have ended it in July. So they ran it for 3 months. The control period remained the same, but it came into operation after this rate of price adjustment was valid for 3 months. They assume that.
So they made it from May, June, July.
May, June, July.
Which should have been from
April, May, June.
April, May, June. They made it May, June, July.
May, June, July.
But whatever may be, there will be an FPPA
There will be an FPPA.
every month.
There will be an FPPA every month.
So what was the FPPA here? Because we have to see
Yes.
out here, these are very fine things which
Yes.
we are required to look into it. What is the difference?
Yes, Your Lordship.
Let us see the FPPA for this. How much is the kilowatt? Let us
Is-
see page 33.
Page 33.
Is the particular.
If Your Lordship has page number 32,
Now kindly see FPPA charge.
yes, 0.7.
No, kindly see this amount, how 3,52,920,
Lordship is at page number 32.
33.
Yes, 30, yes, the same, it's the same. 32 is the first bill which was raised after the revised charges were, revised price adjustment charges came into force.
32.
32.
Now 32, you see FPPA charge is 4,85,808.
Yes.
Next year it is, next month is
3,52,000.
3,52,000. 920.
Yes, the rate remains the same. Your lordship will see the rate,
Rate is 0.7.
0.7.
0.7.
0.7
0.7 is the FPPS charge.
is the charge.
This is for the year. Why have you put 0.7 here? If it is in the month of June, it is, oh yes, all other categories, 0.7.
0.7.
So therefore it is 0.7 is remains the same.
0.7 remains the same.
So how does it make a difference, Mr.
Because after the notice is issued, they can do it from the next quarter only.
Understood, but
Yes.
for the earlier quarter also, they can do 0.7.
Without notice, they cannot do it, my lord. Without notice, they cannot do it. Notice is to be issued, my lord. for
So
the-
you mean to say
Yes,
that without a notice,
Yes.
there cannot be a charge of FPP.
FPA. And secondly, my lord.
And as they have done the notice later on,
Yes.
and as such, they cannot charge
Yes.
it. Let
And
us see
moreover,
why.
another aspect, my lord. And
No, let us see why do you say
page
that?
61 also another aspect you must to see.
Page
Page
61.
61, their affidavit. This is another, my lord, point I came now. This is the ARC, my lord, letter. Second paragraph, your lordship may see. It may be mentioned here that as proposed in your letter under reference above, the ARCC FPA regulation has no provision for levying defined rates for FPA for defined categories of consumers. So they are making it defined category.
But that is not a subject matter of challenge.
Now, my lord, because this letter was not with me. Now I have, I'm taking it, madam.
So, but that is not a challenge on that. You are not challenging on that aspect that whether there can be 3 different categories. That's not your case.
My case.
Your pleaded case.
Yes.
That's not your pleaded case.
Not related case, my lord. But now this letter I found, my lord, that is why I.
Very good. That letter is being given. You have to file another, ask your client to file, make it, instead of 2, make it 3 writ petitions. You're doing, but otherwise you cannot.
Yes.
I cannot permit, but anyways, show me that this is for March. There is a requirement of payment fixing. Absence of- Now, what is this petition number? This annexure A, Assam Electricity Regulatory Commission.
Yes, that is the tariff order.
So here you have LT Jivandhara Domestic.
If your lordship has page number 60, there is a small asterisk at the bottom of the page.
Hmm.
It says inclusive of existing FPPA charges.
Hmm.
So this asterisk has a reference to the increase or decrease in tariff at the top of the table. So since this was there in the tariff order, there was some ambiguity whether we could levy the FPPA separately or not. So that was clarified by the AERC, and then we proceeded.
Now, show me the earlier notification prior to 27th May. Because this says until further orders.
Yes,
Until further orders means until further orders.
yes.
Prior to that, your lordship, I have been instructed, perhaps my learned friend will be able to clarify the position. The AERC was levying the FPPA as a part of the tariff order, instead of a separate notification.
Yes, Mr. Das.
That I have been instructed, but I do not have the records, your lordship. But the FPPA was definitely in operation.
Now, where is the requirement that it has to notify the charges? As per the rules? The amount of so and so.
Well, that is a-
B is equal to BF so and so, so and so. Will be station.
5.4 proviso, my lord.
Huh?
5.4
Implemented.
proviso.
FPI will be recovered in
Last,
the form of
second proviso.
incremental charge
Shall put
in
up
the
on its
proportion
website.
to the energy
With some additional
consumption
burden
and
on
will be
account of
forming
charges
a part
will
of the
price and
energy
cost.
bill
Cost. The FPA
to
charge
be
levied
served
on all
on
consumers.
monthly or on
This
period.
quarter, along with.
Now kindly come to 5.1.
Yes,
5.1.
5.
The FPPA will be recovered in the form of an incremental energy charge in the proportion to the energy consumption
Yes.
and will be forming a part of the energy bill to be served on monthly or any periodical basis. Charge will not exceed 25% of the variable component of the tariff or such other ceiling as may be stipulated by the commission where the variable will be applied at the end of each quarter by the distribution licensee without making it necessary to go through regulatory proceedings. The distribution licensee shall, however, be obligated to provide all relevant input to the commission simultaneously. And in any case where the commission observes any discrepancy, the same shall be adjusted during the next quarter. Now, this 5.3 gives you the power to do so.
5.3, yes, Your Lordship. This, Your Lordship, our requirement, 5.3, the formula will be applied at the end of each quarter without making it, so only if it's more than 25%, we need to.
No. 25% is 5.2.
5.2?
I'm saying about 5.3.
Yes, Your Lordship. So since an FPPA was already being levied or it was a part of the tariff which was fixed by the.
The part of 5.3 says that the formula will be applied at the end of each quarter by the distribution licensee.
Yes.
Without making it necessary to go through the regulatory proceedings, means you need not go to the AERC.
Yes.
The distribution licenses shall, however, be obligated to provide all relevant information to the commission. So you have to keep on informing them
Yes.
simultaneously. And in any case where the commission observes certain discrepancies, just for example, you could not have done that, but it has been, it will be adjusted in the next quarter. Charge is usually incurred by the generating company, which is passed on to the distribution utility. So it is being done by AGCL,
Yes.
who in turn recover it from the end consumers. Therefore, the generating company owned by the state shall also provide all relevant details and supporting at the end of each quarter to the Commission for Reconciliation. Will be made effective from the date of publication of the regulation in the official gazette, provided further that the FPPA charges to each tariff category of consumers will be displayed prominently at the. Now, provided further that the FPPA charges applicable to each tariff category
Yes.
of consumers shall be displayed prominently at the cash collection centers and in the website of the distribution licensee. Now, if that be so, doesn't these regulations on its own provide that there can be more than one category?
There can be more than one category.
Now,
That's
here,
it.
although the AERC says
Yes.
that cannot be, but doesn't the proviso
Yes,
indicates
yes,
that?
Your Lordship.
That the distribution licenses shall put in its website such details of the additional burden on account of changes in demand and power charges cost and the charges levied to all consumers for each quarter along with detailed computation. Each control period shall be a so-and-so. For quarter shall be charged for me. The fuel charge shall be applicable. It shall file detailed computation of actual fuel cost. But Mr. Saivula, where is that provision that it has to be done only after that you can do it?
My lord, this is the, my lord, the next quarter. Next quarter. First month of the next quarter.
No, maybe, but where is it mentioned that it has to be? Unless it is not notified, you cannot charge.
My lord, first thing notification is to be given, my lord, 5.4 proviso.
Huh?
5.4, it says the notification is to be given.
No. This will be different. Well, so and so will be made effective from the date of the regulation in the official gazette. This is the regulation which has to be
No,
published. Otherwise, no.
No, my lord, your lordship see, provided further the FTA charge shall be applicable to each category of the consumers shall be displayed prominently.
Ah,
at
prominently
each
it is okay.
collection center
It will be
on the
displayed.
website of the, so provided.
But
that-
whether there was a change.
There was this because Your Lordship earlier the FPPA was being levied directly. It was a part of the tariff, so we did not have to make this calculation. So if Your Lordship has paragraph number 9 of our affidavit, why this situation came about is explained, Your Lordship.
Lordship, 5.5, the fuel will charges was computed and billed on the deferred basis with consumption in one of the building. For the central bill.
There was a change.
So they included FPPA within
The this tariff order which your lordship had seen at Annexure A, it was this existing tariff price adjustment of 0.5 was subsumed into the the new tariff order. So there was some ambiguity whether we can continue to levy or not.
Therefore, in order to resolve the case of the clarification from ARC on whether FPA could be levied for prior consumption in the light of the text, was informed by the ARC that such levy could be used in terms of the regulation. Formal communication was also. That in fact, if it was given an government. Now what you are doing?
Now your lordship, we are calculating.
The FPPA
Now
separately.
Now, in fact, the formula has also undergone a change because of the new regulations.
New
Regulations. Now it is to be done monthly, your lordship.
has come?
In-
Oh, that has already come in.
Yes, your lordship. That has now been notified. It will not be available to the present, it will not be applicable to the present dispute. But otherwise, that regulations hold the field.
Now it is from 2025, it is every month.
Every month.
So every month they provide the details.
Yes. The details are actually
No, because they have to provide the details as per 5.3.
5.3.
They will provide the details to you
Yes.
and you put it to the end consumers.
No, in fact, your lordship, we have all the details with us. So if it,
No,
If-
no, it can't be like this. You say, see here.
we are obliged to, in fact, we have to provide, if it,
No. Yes, 5.3.
5.3
FPPA charge is usually incurred by the generating company.
generating company.
They will do it,
My
which is
learned friend
passed on to the distribution utility to you.
my learned friend is appearing for the ARC.
I'm not on,
Oh,
but I'm saying
that
about
is-
the AGCL.
AGCL, yes.
AGCL will do
Yes,
it,
your lordship.
and from AGCL it will go to you.
Yes, your lordship.
You will then recover from the end user.
Yes, because
So every month AGCL informs you
informs us.
that this is the amount,
This is
and
the
then on the basis of that you do it.
we do it. And if it crosses a certain percentage of the base tariff, only then we have to take special permission from the regulatory commission.
Why?
It says so at 5.2, your lordship. For example, if the tariff is 1 rupee and if it is more than 25 paisa, then the commission has to give its approval.
But if it is 0.170,
Yes, that will, but 0.7, yes.
that would be how much?
It will depend on the
Percentage?
base tariff. The base tariff is the energy charge, the base tariff is 7.5, 7.05 in normal and 9.5 with peak hours. Your lordship will find it at the bill, your lordship.
And night is 5.
Night is 5,
So it is less than.
less than 25.
Less than. So you don't need to inform the
we don't
AERC. And what happens if 0.70 is taken? And if this 0.70 exceeds 25%,
Yes.
taking into account the nightly tariff, you're having 3 tariffs.
Three tariffs.
What happens then? 0.70 is into takes care of the nightly tariff. If it is just for example, it is 3. Then
Then
it
the
is beyond.
Then the procedure under 5.2 will be applicable.
But for nightly tariff, that will be
the
there
second part, yes, your lordship.
for that night.
Yes, your lordship. The second part of 5.2 will be applicable.
So prior to June,
Yes.
prior to, in the month of April, you did not charge them.
We did not. We have specifically said in paragraph number 10 that because of this ambiguity, we did not charge any FPPA for the month of June. And it was the amount calculated for the control period of January, February, and March was only added to the electricity bills of consumers from the month of May.
May. So
May,
April,
June,
April, what happened?
April, we have deferred it. April, we have deferred it.
So there is more burden in the month of May, June.
In fact, what they have done, Your Lordship, is instead of ending that calculation in that tariff should have run for 3 months.
Maybe the 3 months.
They have done it for 3 months, May, June, and July.
Because if it is 2 months, then it exceeds 25%.
No, their interpretation of 5 point of the authority was that since it is, if Your Lordship has 5.5, it says that the FPPA surcharge shall be charged from the first month of the next quarter. So they assume this implies that they have to run with that tariff for at least 3 months. So even though the next control period started
But
from April,
if it is just, for example, if you don't give the exclusion to the month of April,
yes,
then you can do only till May and June,
April, May and June.
applying 5.5.
April, May, and June.
Then if it is done for May and June, then how do you recover if we just put it 0.70?
If we had only run it for
Because you are doing it 0.70 on the basis of a 3 month,
3 months, if we had,
isn't it?
yes,
If you are doing it on 0.70 on 3 month basis, meaning thereby you can recuperate the loss or the amount which you have spent by imposing 0.70.
if we,
Because if it goes beyond that, if you are making it in a 2 month period, then it may exceed the 25%.
it might have exceeded 25% also.
Likely to exceed.
So,
Because you may have to be, if you go as per strictly for 5.5,
so my simple calculation would be since it's 0.7 and we need to adjust that in 2 months instead of 3. Yes. 0.35 paisa more would be included to the monthly price adjustment for each month, Your Lordship. I'm just dividing 70 by, so it will be 0.35 paisa would be added more. So it will, instead of 0.70, it would be 1.05 paisa.
so then also it will be 20% of the nightly tariff.
But since
There's no
they
problem.
assume that they would be running it for 3 months, so they calculated it at 0.07 and
And therefore it got deferred by 1 month.
it got deferred by 1.
Now what to do here now?
My lord, actually this, my lord, they have to notify the consumers that this should be charged for the next quarter. Next quarter. They cannot give a, my lord, notice which have to.
Where you pay, did you pay for month of April? FPPA.
My lord, that is inclusive, my lord. That is inclusive of, yeah, my lord.
Where is it? Show me your bill for the month of April.
No, April, that is not with me, my lord.
You being
April
on
bill is
record
not-
that, then we can get an idea how it is. How did it differ? Because we are concerned with the month of May. This is the month of July. You have enclosed, then you have June. June would be for the month of May. For the month of May, I think the payment. will be
January,
for
February, and
June.
March,
The
Your Lordship.
period will be, bill period will be
Ja-
from the 1st of May to 31st of May.
June, yes,
This is June.
yes.
Produce the bill for the month of for the bill period 1st of April to 31st of 30th. You'll see that. Then we'll get to know.
Yes, they
what
got
it
them
is.
paying it at the previous rate of 0.5.
So how did you happen?
Yes.
Whether FPPA was charged or not, or whether FPPA, because they say that FPPA was not charged.
No, it was charged. The revised rate was not charged, Your Lordship. The revised rate was not. The earlier FPPA was 0.5, Your Lordship. That was subsumed into the rate of, into the tariff order. So when we calculated it for the month of January, February, and March, from 0.5, it increased to 0.7. So since the earlier rate was already a part of the tariff order, that is why it led to a situation where we could not levy the changed rate of 0.7. So that is why we wrote to the ARC for a clarification. So by the time that clarification came, the month of April had already passed. They were charged the FPP at the previous rate of 0.5, which was the existing rate prior to
So
January.
it should
February.
have been 0.7.
It should have been 0.7.
But then how do you recuperate that with 0.7?
So
If you are charging 0.5, also you are making it deferring
3
it.
months.
No, it is not a question of deferring. You are making it the deferring the quarter.
deferring the
Quarter.
revised rate
No,
by a month.
no, deferring the quarter.
No, the quarter has remained the same. Your
The
Lordship.
quarter cannot remain the same because you are deferring the quarter because you are saying from the month of April you are not
Yes,
doing
yes,
it. You are doing it from the month
The
of
billing
May.
quarter we have
So
deferred.
May to July you are
bi-
making it.
the
It
billing
should have
quarter-
been from April.
The billing quarter we have deferred.
So for these 4 months you had one FPPA,
One FPP of
which
0.5
is we brought within the ambit of
tariff order.
tariff order.
Yes, Your Lordship. And since it was within the tariff order, it led to a situation where whether we had
Now,
now
when did this normalize?
it normalized from the month of May onwards, Your Lordship.
No, it
issuance-
shouldn't have been. So you are deferring it by 3 months to the month of July.
Yes, Your Lordship.
So it should have otherwise ended in the month of June.
Yes.
So to July. Then from July, August, you are doing it to August, September, October. Then November, December.
My
then how
instructions
do
are
you
that it has been deferred for the continuation of this notification of 2010 till the new one came into force.
So you continued like
We
this.
continued.
So these three months. it
Yes,
has-
there was a delay of a month.
So it has been delayed by. what?
Delayed by a month. Because otherwise, the claim of retrospectivity which they have raised, Your Lordship, that would perhaps even not be applicable because the bill itself shows that it's for a previous period.
Now, Mr. Saiwala,
Yes.
why are you troubling this court with these complications when you have 5.16? This court is more used to contractual bills. Now you have made this court enter into all these things when you have 5.16.
No, my lord, if your lordship see, my lord, the next notification also, because we have challenged two notice, as page 48. Again, my lord, this has been done.
This is done because of they're postponing it by
No, my
1
lord,
month.
here, my lord, they are doing it from October to December, my lord, but it is they are charging, my lord, for the consume period of September also, my lord. This
No,
is
for the energy consumed during September
Well,
also
this
will
is
be
retrospective,
replaced
ma'am.
by the order.
This is retrospective, 29/9 they have issued this notification.
Huh?
They have issued this notice on 29/9. So this is retrospective.
Why?
Well, from what a,
Now this one they are doing it for the month of October onwards.
no, October,
No,
for energy
this-
consumed during September 23.
Yes.
For the energy consumed during October, September 23. This is retrospective, my lord. Similarly, this earlier one. That is the, my lord.
No, Mr. Sahawala, only after the energy is consumed,
Yes.
the AGCL is going to provide them the inputs. Then only they are going to do it.
My lord, here.
Now,
right-
how will, just tell me, Mr.
Yes.
Sahawala, how will APDCL or AGCL know how much energy would be consumed in the month of May? Or just why we are in the month August for the month of September? It is only when the amount is being spent, then the AGCL will place it to them. Thereupon the AGCL will put the APDCL sell pass on to the end consumer.
My lord, my reason is this, my lord. That is why this regulatory is given, that it will be from the next quarter only. My lord, first quarter is January to.
Understood.
March.
So what they say,
Yes.
we have deferred it.
But that cannot be done, my lord, here, my lord. Why I am submitting, my lord, that this notices are issued with retrospective effect, my lord. This is the,
I think Supreme Court can help you out.
my lord,
Let me dismiss your petition with
my
Mr.
lord, because your lawsuit will see 27th
No,
May.
Mr. Sahawala, this is not the question this court is going to look into all this. This is too much. Mr. G. N. Sahawala, the learned senior counsel, they are both petitions same.
My lord,
Court petition.
What is the other petition for?
same.
This is for different periods.
Different
Namely-
meter numbers,
Different meters.
different meter numbers.
Or different meters. Okay. Heard Mr. J.N. Sahiwala, the learned senior counsel, assisted by Mr. H.K. Sharma, appearing on behalf of the petitioner in both the writ petitions. Mr. K.P. Pathak appears on behalf of the PTCN and Mr. S.P. Das appears on behalf of the Assam Electricity Regulatory Commission. The petitioner herein have approached this court by filing two writ petitions, taking into account that the petitioner is aggrieved by the imposition of FPPA in respect to the 2 meters which the petitioner have been petitioner's establishments are connected with. The dispute pertains to the application of the fuel power purchase price adjustment and the imposition thereof in terms with the Assam Electricity Regulatory Commission bracket fuel and power purchase price adjustment formula bracket close regulation 2010 for short the regulation of 2010. The petitioner herein is a partnership firm carrying on the business of large scale business of manufacturing of MSTMT bar at the Integrated Infrastructure Development Center, Rongia. The petitioner factory is connected with two electric connections bearing consumer number 08 0 1897 and 08 0 1898. It is the case of the petitioner that in terms of the regulation of 2010, which have been amended by the Assam Electricity Regulatory Commission bracket fuel and power purchase price adjustment formula bracket code regulation 2010 bracket amendment 2012. The fuel and power purchase price adjustment, for short FPPA, is to be implemented in terms with rule regulation 5. The learned senior counsel, appearing on behalf of the petitioner, submitted that in terms with clause regulation 5.5, each control period shall be a quarter, that is 3 months. And the distribution licensee shall compute and adjust the amount as fuel and power purchase surcharge. Full stop. The FPPA surcharge for the quarter shall be charged from the first month of the next quarter. The learned counsel, senior counsel, drawing the attention of this court to the notice dated 27th of May 2023. As well as the notice dated 29/9/2023 submitted that the same notices were issued, which is contrary to to regulation 5.5, inasmuch as the respondent authorities by the notice dated 27/5/2023 had fixed the rate, fixed the FPPA to be levied to the respective category of consumers for the 3 months with effect from June 2023, bracket energy consumed during May 2023, and by the notice dated 29/9/2023, the FPPA was charged from the month of October 2023 for the energy consumed during September 2023. The learned senior counsel submitted in terms with clause 5.5 of the regulation 5.5 of the regulation of 2010. Each quarter would the quarter as referred therein would mean January to March, April to June, July to September, October to December. He therefore submitted that a perusal of the notices dated, impugned notices dated 27/5/2023 and 29/9/2023 would show that the same have not been made in terms with by applying clause 5.5 inasmuch as it has been done for the month of June 2023 to August 2023. And from October 2023 I think this is being regularized, I thought. The last
From June to August and then September to October, September to November. It says, Your Lordship, the second notice for energy consumed during September 2022. Energy consumed during September 2022. So since bills are only generated after a month. For example, if your lordship has the bill,
So this is from, for the next 3 months with effect from June. Meaning when June, July, August.
yes, June, July, August. So then September, October, and November.
So this will be till September. This is only for 3 months, which
This
will
was-
be October, November, December.
No, no, September, October, November, your lordship.
No,
June,
no.
July, August. The consumption period is 1 month prior, your lordship.
Understood. That is okay. But you see, from the month of October 2023.
Yes, the bill will be.
Leave it from the month of October 2020.
Yes, so if the bill is generated on the 1st of October.
So it will
for-
be for 3 months,
Yes.
October, November, December.
My understanding is that it's the word September.
This is regular, this is okay. For notice
Sep-
of 27/5/2023, it's okay.
Yes, your lordship.
Here they are doing it for the month of June.
June.
But you see, for next 3 months with effect from June 2023.
Yes, your lordship.
We are not concerned where it was consumed.
Yes, your lordship.
Consumption is what they inform,
Yes, your lordship.
but it will be from
Yes,
June,
yes.
July,
If
August.
the billing period is taken, then it will be 1 month later. Yes, your lordship.
June, July, August.
August.
Which does not, it should have been from July to September. Normally,
Yes,
it is the third quarter.
It
But
was
here it has been done from June, July and August.
August.
But here it seems to be regulated from October, November, December.
No, it is, if your lordship has paragraph number 11, you
Uh,
have clarified this also in the
Uh.
affidavit. This has continued in the next one. Those are my instructions.
hey, Mr. Sayola, from here, October, November, December.
No, October from October month, my lord, if they charge, my lord, there is another aspect. But here, this is given, my lord, from energy consumed to September. The notice is given, my lord.
Energy consumed will be always prior to that. There is no quarrel with that. I'm not on that. But here, you see, earlier, it is not going by June, July, August.
Ah.
You see, for the next 3 months with effect from June 2023.
Yes.
Which they should have had from April 2023.
Yes.
They are making it from the month of June 2023.
But my lord, it says, my lord, as per 5.5, the first, from the first month of the next quarter. First month of the next quarter. my lord.
So this will be from May to May, June, July.
It should have been January, February, March. So April, May, June was the billing period. July, August, and September would have been the next quarter. So
No, this, as per this, 27th of May 2023, the 3 months would be what? Page 31?
lordship. As per this, the 3 months will be energy consumed during May. So it will be June, July, and August.
That is what I'm saying.
Yes, your lordship.
But how do you take care of page 48?
Yes. So June, July, and August, those months are covered. So from September onwards, though it's notification.
But
was
then tell me at page 32.
32, your lordship. Yes, lordship will kindly see the billing period at the top of the page. It's for the
From
previous
1st of May.
1st of May. So the
So
bill,
for the month of May, you are doing it.
yes, we have we have deferred it by a month. It should, instead of being April, May, and June, this May, June, and July. So the month of August, your lordship, the month of August,
So here after June, May, June, July, August, September, October.
it should have been August, September, October, but it has been September. It is now made September, October.
But again, you have changed it. How did you change this one? Or you did not change for 5 months?
No, it says that in paragraph number 7, I asked them about this. They said that we let it run for 3 months, and from the next quarter.
No, it can't be then. Then how do you take care of it? If we take this for 3 months, May, June, July.
Yes, your lordship.
That's the billing period.
That's the billing period.
Billing period for May, June, July would be June, July, August.
Yes.
Okay. Then for September
Yes, your lordship.
would be, for August, it will be in the month of September.
For the month of August, it will be in the month of September.
Where is the August month? Means again you have You
There is
must have
again a
used it
difference.
for more than 3 months.
There is a difference of a month, your lordship.
It seems to be, because then you have from the month of September, you are having the billing period, for which you are having for October, November, December.
Yes.
If you are having for October, are you not regularizing that period again? That is why I'm saying.
Yes. I'll just, if your lordship allows me, I'll just take instructions on this aspect, your lordship. I understand what is falling from your lordship, that 1 month is missing apparently.
Somewhere there appears to be two.
Yes.
Means either you have applied the 27th May notification for another 3 months.
Yes, your lordship.
He may have a case on the aspect that these 2 months somewhere, because this is only for 3 months.
Yes, the first one is for 3 months.
If you have not issued any notification for the month of August,
Yes, your lordship.
can you impose this? Because you say for next 3 months.
I'll just get instructions on that, your lordship. I understand what is falling from your lordship.
Mr. G. N. Sahewala, the learned senior counsel, submitted, drawing the attention of that the notice dated 27th of May 2023 would show that the same have not been applied in terms with regulation 5.5. And the period have been shown and the FPPA have been charged for the month of May, June, and July. For the billing period of May 2023 to June 2023 and July 2023. In the bills of issued in the month of June 2023, July 2023, and September 2020, August 2023. The learned senior counsel further submitted that a perusal of the notice dated 29/9/2023 also shows that there has been an increase in the FPPA, triple PA, by the notice dated 29/9/2023. To be levied from the month of October 2023 for the energy consumed during September 2023 until replaced by any other order. The learned senior counsel therefore submitted that a mandate of clause 5.5 of the regulation 5.5 have not only been taken care of, have not only been followed, but also the said notices have been issued without giving retrospective effect. Justo. I have done this judgment till here. We'll take it up on tomorrow at 2.
Very well.
And we'll finish it off.
Very well. So
With the matter tomorrow
I
at
need
2.
to get instructions on whether what has happened for the month of
We-
August.
There seems to be some problem here because here it seems if you are now doing it for the billing cycle of October, November, and December, these 3 months is now being taken care of. Because there is one missing, you see, there are 2 missing links. One is April, which you have duly explained
Yes, your lordship.
why you have done it.
Yes, your lordship.
So from the month of billing circle of May, you are doing it.
Yes, your lordship.
But in the month of August, somewhere, because you are having it June, July, August
Yes.
is the billing cycle.
It is the billing cycle.
But this is for the purpose of May, April, May,
June, July,
June and July.
July.
So till August you are having. But for the month of September you are having it. Meaning 1 month somewhere is gone of the August.
The month of August
Is
is
not there.
not sure.
So how do you take care of this? Means therefore these 2 months being gone, this 3 months is now being taken care of. So therefore now again from the month, the year 2024, you can have from January to March, March to year. So you
Yes.
get an idea of how you are, because this draft came only in 2025.
Yes.
So therefore, I think from month of January, you must have been 2024, you have got it done.
Not.
It appears so. Because this ends in the month of December.
I'll get this aspect.
Normally, it should be, my lord, suppose for the month of January to March, what will be the charges that will be recovered from
Month of
May,
April.
April, May, June, my lord. Normally,
Not-
this should be done.
Done.
So consumption should be from April onwards, my lord, not that January, my lord.
Huh?
Not that of January.
No, consumption is not January.
No. They are to fix that amount, the FPPA on the basis of the consumption for the month of January to March, which AGCL shall inform the APDCL that this is the amount which we have spent, which they will AGCL will recover from APDCL. APDCL then shall put it to you. So therefore you are to fix it. Now if it goes beyond that, 25%, they have to take the permission from the ARDC. Because this is more important. Here they have, if you see the 29.9 notice, they have put you at 1.259.
Yes.
Yes.
Now 1.29, if they have taken it, I think this crosses the 5.05 if it is not wrong.
If only 5 point, then definitely a lot.
Because that is why I also put that question to
Yes,
you.
a lot.
That if the rate at night is 5.05,
Yes.
one, it is okay. But if now it is 1.29, have you taken? Because 1.29, then it would be, it's beyond 25%.
Yes, a lot. I think it's just less than 25%, a lot.
Find it?
Maybe just
Tomorrow.
lot.
Also, we have filed our affidavit, Your Lordship, on this matter.
File affidavit,
Yes, Your Lordship.
Madam.
And verification that total admitted amount on this Joyanta Bhagavati is 1,48,647.
How much did the petition claim?
Two lakh 89,970.
This is for which period?
Fifteen, 16.
15, 16, Your Lordship. They have claimed 2,89,878.
About in लिखी दिखो. About in लिखी था. Pursuant to the order passed by this court on 23/7/2025, a verification was conducted by the respondent authority. And it was found that out of the amount of rupees 2,89,878 as claimed by the petitioner is actually entitled to an amount of rupees 1,48,647, which have been duly mentioned at paragraph number 3 of the said affidavit. Full stop. Further to that, the said paragraph have been further supported by an enclosure marked as Annexure 1 to the petition to the affidavit in opposition to the said to the affidavit in opposition. Considering the above, this court therefore disposes of the instant writ petition with a direction to the respondent authorities and to pay the amount of rupees 1,48,647 to the petitioner within a period of 6 months from the date a certified copy is served upon the respondent number 2 after carrying out the necessary statutory deductions if so required. This court further this court further observes that as the remaining amount of 8282 minus 2,89,878 minus 148 minus has been disputed by the respondent authorities by filing the affidavit, the petitioner would be at liberty to approach the civil court seeking redressal of its grievances. I think in all the cases you have filed affidavit?
Yes, Your Lordship.
এইটো এনেকে কৰি তিনটা আকৌ কি লিখি বিচ চৌধুৰী আকৌ কিমান ক্লেইম কৰি থাকিব
Public.
23. May I please, Your Honor?
Yes, Mr. Botago, what is
Non-payment of contractor's bill, Your Lordship.
contractual bills? Never thought that Mr. Botago will appear for
No,
that.
Your Lordship.
There must be something, yeah, Mr. Naik comes here, so which means there's some.
Lordship. What has happened here, Your Lordship? The work was for 3 years, Your Lordship, issued by the GMC. First 2 years, entire payment has been made, Your Lordship. So far as third year is concerned, Your Lordship, 33% has been released to me, Your Lordship. Rest, Your Lordship, was not released in respect of 2 works awarded to me. Your Lordship will get the issue of notice to proceed work at page 18 and 19, Your Lordship.
Then you file a suit in view of paragraph number 4.
So far as Your Lordship, that is your so far as that paragraph number 4 is concerned, Your Lordship. In fact, what they have said, Your Lordship, that there is no third party. It says, Your Lordship, it is further, accordingly the file was processed for further necessary action.
Inspected by the executive engineer division.
It was observed by the superintendent, no
was
document, a
issued by the
supervision carried by
director.
third party monitoring agency was furnished. This is the reason, Your Lordship. Now, Your Lordship, that is there, Your Lordship. I have
Supervision carried out by the third party monitoring, yeah, but funny.
page 26 of my writ petition, Your Lordship will find, Your Lordship. Not 26, this is set for second year, third year is at page 30, Your Lordship. This is the third party monitoring, Your Lordship, in respect of the third year period, Your Lordship. 1/12/2019 to 31/10/2020 period of work. Now, once Your Lordship, that is there, Your Lordship, the ground they have taken, Your Lordship, just for the sake of disputing, Your Lordship, probably that will. And 33% already paid, Your Lordship. And second ground, they have, Your Lordship, in the latest stage, later stage, Your Lordship. Completion certificate was also issued by their authority, Your Lordship, at page 31. After, Your Lordship, everything has been done. After, Your Lordship, this was, Your Lordship, work was completed in the year 2020. They have constituted a committee, Your Lordship, in 2000.
So where are your photographic evidence?
Everything, Your Lordship, we have, and Your Lordship, so far as their photographic evidence is concerned, in the work order, there is no such stipulation that photographic evidence will be required. That, Your Lordship, Only thing, your lordship, third party
No,
monitoring.
no, Mr. Bothakur, can you understand? This
Lordship.
court can only direction verify and pay.
Lordship.
They don't agree. Then what direction should I pass?
No, your lordship, on the face of the documents and everything, your lordship, the ground they have taken is, your lordship, there is no third party monitoring. I have annexed a copy of the third party.
They also said there is no photographic documentary of the photography regarding status, review, monitoring of entire allotted work was furnished by them by the then concerned executive engineer division 5, they accept the completion.
In that
report.
case, they will have to come up with some documents to say that this was the requirement of the tender condition, your lordship. The photographic evidence, your lordship. Suddenly, your lordship, they cannot
No,
bring.
so you mean to say that this court should pass an order that these things are not required?
Lordship, apparently from the record, unless they produce something, your lordship. If they come up with some materials, your lordship, some documents, some, that this is the requirement, your lordship. In the affidavit, your lordship will find that they have referred to a committee, but committee's report is also not annexed, your lordship here. And this committee, when it is constituted, that has also not been there, your lordship.
Mr. Bothakur, this court is not going to go into all these things. I'm not going to go into all this.
Lordship. Now, your lordship will kindly see the when everything is there, your lordship, they have paid me 33%, your
File
lordship.
summary is good.
All of a sudden, they have come up with the plea that there is no photograph. Then why have you paid me 33%, your lordship, of the third year, your lordship? For the third year, your lordship, 33% already paid. And it is not that, your lordship, at any point of time before coming before this honorable court, they have come up with any plea that you have not supported this and we have rejected your prayer for this, your lordship. That is not there. When we filed petition before this honorable court, your lordship, at a later stage, your lordship, they have come up with this plea that, your lordship, this photographic.
Where have you last received the amount?
Lordship, 33% I have been paid, your lordship. I have made a statement. Para 10, your lordship. Similarly, 10 and 11, your lordship.
So you have got various amounts.
Lordship, first 2 years I have been.
Completion survey and bill amounting to 90 lakhs.
Lordship.
Then paragraph 8 says third period for maintenance.
Lordship.
From Iman to 18 for cleaning.
Lordship.
That is 30 lakhs.
Lordship.
Then from 18 to 30, 11 for cleaning.
There are two packages, your
36
lordship.
lakhs, you have got it.
Lordship.
Then here
10, your lordship.
10 lakhs,
10.
20 lakhs is remaining.
In
Fourth period, bill period maintenance from 36 Iman to Iman.
24.
11 lakhs paid, 54 remaining.
In two packages, your lordship. Out of these two packages.
Now this is for cleaning of the
Cleaning.
roads.
Lordship.
And what is this college is doing, third party?
They have been appointed as, your lordship, third party.
Lecturer, civil engineering, PCP
Lordship.
college, polytechnic.
This
They
is
are
the
being instructed to.
monitor,
give
your lordship.
certificates.
Lordship.
Huh?
That is how.
Mr. Nayak,
Lordship,
you appoint this way. Where is your contract? Let us see.
Lordship, may I start, Lordship? Lordship, we are in this petition concerned with two contracts, Lordship, one at page 18 and one at page 19. Lordship, may I kindly see page 18 and
Page
page
18
19.
and page 19.
Yes,
Yeah.
issue of notice to proceed with the work. If Lordship comes to the reference portion,
Hmm.
office order number so and so, last digit lordship may kindly note, this is 26 of 23 to 2018. So this is one project lordship, 26. And second one is 22, page 19.
23-2.
Both 23 But-
One is 26 and 22.
22.
Yeah.
Now lordship will first notice the completion certificates annexed by the petitioner lordship. If lordship comes to page 21,
Yeah.
lordship may kindly see the last line of the paragraph, lordship, before the table, above the table.
Which
This is 28.
is different.
This is different. Then if lordship comes to again to page 24. Page 24, last line of paragraph 20. This is the
24.
completion certificate petitioner is relying, lordship.
24.
This is 24, not 26 or 22. Another completion certificate is there, lordship, at page 29.
It is 28.
This is again 24.
This
So
is
we are
28,
concerned
page
26 and
27.
22, whereas completion certificate has been
Now,
annexed.
what about this one? 24?
This is another, this is a
This
different
is also
project, lord.
24, page 29.
Page 29, this is also 24.
24.
So we are concerned with 26 and 22. We was asked to proceed with 26 and 22. These are different row of lordship. First,
Oh. Yes.
that is one lordship. Secondly, lordship, this monitoring report issued by the third party lordship. These are so general lordship. Language is same in both the report lordship. Lordship will notice same language.
And they don't refer to which contract.
Your lordship will package number CDV Ganeshguri flyover to Bahini River, Hengarabari. This is the only project, your lordship. 20,
No, these are different. Other things are different. Here, these are work orders are different work orders.
no, your lordship, this is the only work order and this is for this period, your lordship will entire work
No,
order, your
this is office order number. Where are the office orders?
lordship will kindly see reference office order.
No, Mr. Bhattakur, where are the office orders?
No, office orders were not given to me, your lordship. These are the orders.
Are
which-
you saying that without office orders, there is no contract in
No, your lordship, we have been issued with only your issue to notice to proceed with the work, your lordship.
No,
Rest we have not been, your lordship. I will explain it, this.
no.
This is the period lordship.
Doesn't arise. This court is not going to look into all these things.
2018 and 2020, your lordship work, your lordship. And your lordship will find the package number C and D, DVE in GMC area bid by so and so. And your lordship, the cleaning and distilling and your
You
lordship.
have not enclosed the contract.
Contract, your lordship, we have signed in their office and we have not been provided with copy of the anything. What we have done, your lordship, that was with them, your
Have
lordship.
you mentioned in your petition?
No, that I have
Yeah.
not meant, because your lordship, that issue has not been raised. And
Not
even what my
necessary,
learned friend
because
is
these are
submitting, your
in-
lordship, that is not part of the pleading, your lordship. They have not
No,
pointed out
Mr. Kindly come to page 24.
24, lordship.
This is which order you are referring to?
This, so far as this is concerned, your lordship, this payment has already been made, your lordship.
Not understood, but this is in respect to which order?
Your lordship will
Order
kind-
number GERC
lordship,
1360.
Bisturava pot drain from Beltola Sariali to, that is your lordship,
How many contracts were awarded to you?
two. Two packages. Two packages for 3 years. For each year, your lordship, there is separate bills, separate your lordship monitoring, separate completion certificates, your lordship. And first year, second year, entire amount has been paid, your lordship. So far as the third year is concerned, that 33% of both the work has already been paid, your lordship. Only, your lordship, this 66% they have not paid.
So here the petition is only for that.
That's 66%, not
That
the
is
entire.
around 40 lakh.
Lordship, that 23 lakhs and your lordship, around 43 lakhs, your lordship. Now, your lordship, before that, your lordship, they have never intimated to me that these are the requirements you will have to produce. And even in their affidavit, your lordship, they have not said that these are the requirements under any of the terms and conditions of the agreement, your lordship.
First of all, how will it, is it for them to prove it?
No,
That you are
you-
entitled to that amount?
No, your lordship, I
Your-
have,
Your completion certificates do not mention in reference to that work order.
this is the, your lordship will kindly see page 30, your lordship. That is the certificate of the third party monitoring, your lordship. This, of course, your lordship, this does not refer to the work order, your
Then-
lordship. Only to the
Yeah, forget about the third party.
lordship.
Show me
Now-
the completion certificate which refers to the work order.
Lordship, your lordship will kindly come to page 31, your lordship. Your lordship will see, they have not referred to anything here, you know, C and D, VE in GMC area.
This is not completion, this is monitoring.
This is the completion, page 31. Here, your lordship, they have not referred to only to package number, your lordship.
But why in earlier completion certificate they have mentioned?
That, your lordship, they can,
There's something must be.
lordship, that your lordship can, if lordship, that cannot
Not
be
satisfied.
presumed unless they come up with at least pleading that these work orders.
First of all, why will they come up with pleadings when you are deficient on pleadings and placing documents before this? law?
Lordship will kindly see, your lordship, that so far as the other 2 years is concerned, your lordship, that learned friend has been showing to this honorable court, your lordship, those where your lordship already payment has been made. Now, in respect of third year, your lordship, that starts from page 30, your lordship. When it starts from page 30, your lordship, there is no reference to any.
Are you saying that you don't have the work orders, these office orders?
No, your lordship, I have been issued with this. If necessary, your lordship, I will file an additional affidavit stating that, your lordship, since that has, lordship,
I'm not satisfied.
lordship.
Mr. Asbotago, appearing on behalf of the petitioner, submits that taking into account the submissions so made by Mr. P. Naik, appearing on behalf of the respondents,
Yes.
you'd like to file an additional list after?
Lordship. 2 weeks, your lordship.
Oh,
Lordship. Deeply obliged.
24.
May I plead your lordship, this is a non-payment of contextual bill. This is the second time litigation by the petitioner. Earlier, the petitioner filed the 6 numbers of writ petition for non-payment of contextual.
Yes, what is your stand?
And my lord, during pendency of the writ petition, they have paid the 10 lakh each in 4 writ petition, and rest of the 2 writ petition, they did not paying. And no affidavit have been filed till date, my lord.
How much you are claiming?
Actually, lordship, I have.
How much?
I have filed an additional affidavit, my lord, on 24th March 2025, when I have been stated, my lord, that in 6 writ petition, my lord, I am stating in paragraph 2, my lord, that affidavit.
This is PWD.
Yes, my lord, PWD. Already their name have been included in the list, consolidated list where the petitioner name appeared in the serial number 7, 25, 27, 28, 42, and 49. And in 6 numbers of contractual bill amount, my lord. They have paid 10 lakhs after filing this writ petition, my lord, in 4 writ petitions.
Yes, madam, you have put her in, put the petitioner out here in chronological order.
Lordship, new, somehow it is difference now. One is
It's
11.
being
12,
recorded in
13.
this order.
But lordship, here one new list has been given, 11, 12, 14.
Now, anyways, you have put
Yes.
them in chronological
Yes,
order.
lordship, we have.
Now the question is, have you made the payment?
Construction works has been paid 10 lakhs each, and 2, I have to take instruction. She has filed.
You file your affidavit.
Lordship. No, I have.
Good stuff. This is the second round of litigation. Pursuant to directions passed by this court, directing the respondent authorities to pay to the petitioner, to make verification and pay to the petitioner by following the mandate of the judgment of the full bench in Kamser Ali versus State of Assam reported in so and so. This court duly takes notice that in the contempt proceedings so filed for non-compliance to the orders, various orders passed in writ petitions. In contempt petition case number 13/2022, it was brought to the notice of this court that the petitioner have been placed at further in terms with Kamsar Ali Supra have been placed at serial number 7, 25, 27, 28, 42, and 49. And it is on the basis thereof the contempt proceedings was closed by an order dated 1/3/2024. However, the petitioner having not received any amount thereafter, the petitioner has again approached this court. It is seen that this court had issued notice on 14/8/2024. But till date, no affidavit has been filed on behalf of the respondents. List this matter on 17th of September 2025. The respondents are directed to file the affidavit on or before 11th of September 2025 as to whether the petitioner have been made any payment pursuant to the various orders passed in the earlier round of litigation. And the petitioner's name being placed at serial number 7, 25, 27, 28, 42, and 49. So this court further takes note that if no affidavit is filed as directed above, and taking into account that this is the second round of litigation, this court shall pass appropriate directions seeking personal appearance of the parties of the concerned respondent.
And she has admitted 4 cases.
I don't know any. You file your affidavit, how much?
Lordship.
A person can't keep on filing repetition of the one.
25.
Public.
Non-payment. Mr.
I have received one instruction, or if the department has sought for some documents from the deputy commissioner. I need some time.
Mr. J. Hendig, appearing on behalf of the Revenue Department, submits that the department have, that the state department have sought for certain instructions from the Deputy Commissioner.
Majuli.
Majuli, na?
Majuli.
Yes, sir. For conducting the verification as to whether the petitioner is entitled to the amount as claimed. List the matter again on 15th of October 2025, on which date the respondents shall provide an update as to whether the petitioner is entitled to the amount so is entitled to any the amount so claimed or any part thereof by filing an affidavit.
26.
May I pray, my lord, 1 week time, my lord, to get the instruction.
What is this? Non-payment?
Non-payment.
Repairing? Police? Police?
I'll get by next week, my lord. I'll.
File your affidavit.
My,
Miss Udas, the Lalit's additional senior government advocate, submits that she has received the instructions and would be filing the affidavit. in a week's time. List this matter again on 19th of September 2025. The affidavit be filed by 11th of September without fail.
My lord.
It is observed that failure to do so, this court shall be constrained to pass appropriate directions.
My lord.
28 diploma.
Lies. Yes, here, my lord, I have received the instruction, my lord. Now we are to pay it, my lord, 22,41,960, my lord.
Is entitled to.
Now, my lord, yes, we have paid, my lord, 5,20,000. The instruction is sent. Slap
ওপৰ খিনি লিখি দিব।
এইখিনি বাকী আছে।
Mr. ওপৰ খিনি লিখি। It's you that the learned additional senior government advocate during the course of the hearing have placed before this court a communication issued by the Deputy Commissioner of Police Crime, Guwahati, whereby it was stated that as regards the claim of the petitioner of rupees 27,65,246, an amount of rupees 5,23,286 have already been paid to the petitioner. And the remaining amount of rupees 22,41,960 is pending for non-receipt of FOC from the government. The said instruction is kept on record and marked with the letter X, taking into account witness the order to dispose. He had to pay. Dispose of it. 6 months.
29
Oh, my lord, we take for time to file affidavit. It was made ready, but I could not file it. But my lord, our instruction is, my lord, now we are to pay 8,36,796, my lord. 3,45,000.
Same order.
My lord.
Same.
My lord.
It took over beleg hoy gole 3,45,000 total out of 11,65,322 32. An amount of rupees 3,45,271 have already been paid to the petitioner, and the remaining amount of rupees 8,36,796 is pending for non-receipt of sanction from the Assam Police Headquarters and allotment of funds required to make payment to the petitioner. Taking into account that it is admitted, hetu amar line kini ase no inna jedi so 6 months.
Obliged.
30
Yes, what is this?
Lordship, the petitioner challenging the speaking order
My lord,
passed by the
speaking order,
DFO.
yes.
You not file affidavit.
Lordship, there's a provision for appeal against an order of a DFO. There's a provision of appeal, your lordship. That Assam Mine Mill Concession Rules, 2013, Rule 68, there's a provision of appeal, your lordship.
What are you challenging, Mr. Sharma?
My lord, that is
Page,
speaking order, my lord, at page 50.
page
50.
50, my lord. But what happens in this case, my lord? Petitioner was a settlement holder. Initially, settlement was granted for a period of 2 years.
Pertaining to settlement of not. So you were duly intimated?
Intimated.
You paid how much amount?
1,77,000 as kist money, my lord. 1,77,256 as kist money. But no environmental clearance, no agreement, my lord.
Environmental clearance is your business.
Environmental clearance, my lord, we have pursued, but we could not obtain the environmental clearance.
Understood.
agreement
But what
was
do you
entered
say
into-
about 37.3?
Hello?
37.3, isn't it?
Yes.
37.3.
Well-
37.3 Roman
4.
5.
4, 5.
Roman
sorry.
5.
Yes, environmental clearance, my lord, we have pursued, my lord, no environmental
Isn't it,
clearance
Mr.
was
Gogoi?
granted.
37, 30, Rule 37, 2,
3 Roman 5.
Roman 5,
Roman 5, my lord, 37 to
Isn't
Roman
it?
5. First, it is that 10%, then he gets the LOI, then he has to remain 15%.
Well, what happens in this case? Well, we have been directed to obtain the environmental.
Next week, very bad food.
Hello. Well, this money was directed to be paid, even though agreement was not there.
I'm just helping him out, your lordship. There's a provision of appeal before the PCF. This order is passed by DFO. So here's a provision of appeal under Rule 68, your lordship.
But
Here is
that
the
rule,
68. Assam Mining
within what
Concession
time?
Rule. Yes, your lordship.
Within what time?
There's a time frame is there, your lordship, within
68, my lord,
60 days, your lordship.
60 days.
Order passed on 9/5 and he filed the writ petition in 2025. What to do?
Liberty may be given then, my lord.
Huh?
Liberty may be given. Approach the PCCF.
The learned counsel appearing, heard Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner. And Mr. R.R. Gogoi, who appears on behalf of the Forest Department. The learned counsel, Mr. R.R. Gogoi, the learned standing counsel submits that the instant writ petition is not maintainable, taking it ought not to be entertained, taking into account that the petitioner has alternative and efficacious remedy in terms with section 68 of the section or rule?
Rule 68.
Rule 60.
Of the Assam Minor Minerals Concession Rules 2013. Full stop. This court, Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, however, submits that without there being an environmental clearance, comma, the question of entering into an agreement did not arise, and as such, the respondent authorities ought not to have refused to refund his first deposit, in as much as on account of not granting the mining permit, the petitioner could not mining permit, which was beyond the control of the petitioner could not enter into an agreement. This court, having heard the learned counsels, is of the opinion that though the petitioner has a point, has an arguable case, but taking into account that there is an alternative remedy available, which is efficacious, the entertaining of the writ petition, this court is not inclined to entertain the writ petition in as much as there are certain factual adjudication which requires to be adjudicated as to whether the petitioner had taken due steps for applying for the mining permit. Considering the above, this court dismisses the instant writ petition on the ground of not being entertaining. This court is not inclined to entertain the writ petition, for which the writ petition stands dismissed. Be that as it may, this court, however, grants the liberty to the petitioner to file an appeal within 30 days from the date of the present order, challenging the order dated 9/5/2024 before the appellate authority in terms with Rule 68 of so and so. It is observed that if such an appeal is filed, the appellate authority shall decide the appeal without being prejudiced, without being influenced by the dismissal of the writ petition by the present order.
Right.
I gave you the time on.
31.
Yes, what is this? 89 lakhs per base. Oh,
Kindly
yes.
page the last order, my lord.
Lordship,
31/7.
In terms of section seeking assistance for handing over the possession of the city. Oh, this anything done?
Yes.
Lordship,
We have approached the executive magistrate seeking assistance for taking over physical possession, Lordship. But due to his busy schedule regarding this 15 August celebration,
What?
the executive magistrate, Lordship, he has assured us to fix a date soon after 15 August, Lordship.
When 15th August?
Soon after 15 August, Lordship. Actually, he was busy.
When is the next date fixed?
Not yet fixed, Lordship. He just assured
Who is
us.
appearing for the executive magistrate?
He is not a party.
The
Not a party,
ADC,
Lordship.
you are to approach the ADC, who is there? Why haven't you made the ADC a party?
My lord, it is not party, my
No, I can't help you. Mr. Hawk,
my lord.
you have some problems in making parties. That day also, I had to tell you, you have a problem here also. This
Lord,
case I could have very well directed. Your basic case is Punjab National Bank is not handing over the possession.
Yes, my
They are trying their best. Now, how do I help you?
my
It
lord.
is not that they are not doing it.
Right.
They are approaching the ADC.
Right.
Now, how do I give a direction to the ADC?
But-
Tell me,
yes,
give
my
me a
lord.
good
Yes,
idea.
ADC cannot be directed, my lord, here.
So
But-
help me out.
Yes,
What is there to be done?
but our main grievances was against the bank, my lord.
Understood.
Yes,
They cannot, as of now, you are purchasing in terms with the Surface Act,
my,
in pursuant to an action taken under the Surface Act.
my,
So therefore, they are initiating proceedings under 13(4). 13(4), once they are taking the proceedings, they must have taken over the possession.
Possession.
First, not the physical, the other possession.
Right.
The possession by way of publication of notice and all these things, they have taken over. Now, for the purpose of taking the possession by way of physical possession, they cannot do it by themselves. They have to take resort to Section 14. Section 14 involves the executive magistrate or the ADM. So if that be so, if they are approaching them and then they are not doing it, why don't you file an application, make that a
Right.
party?
yes, yes,
Isn't it?
yes, yes, my lord.
Then I can pass some
Yes, yes.
direction to Ms. Yudas to do
definitely.
it. But you can't help it.
Yes.
In the morning also,
In the
motion matter also.
In the mean,
Huh?
in the meantime, I will make party, my lord.
Mr. So-and-so appearing on behalf of the respondent bank submits that steps have been taken before the magistrate, district magistrate in terms with Section 14 of the Surface Act. However, on account of the various, on account of preoccupation, no steps have been taken on behalf of the district magistrate. Mr. Ashok submits that he would like to file an application seeking impleadment of the
Executive
the
magistrate.
district magistrate.
It is the
So
executive
taking
magistrate.
as well as also an additional affidavit. Pustam, list this matter when?
My lord. Next Thursday, my lord.
Huh?
Next Thursday, my lord. I will make
Next Thursday.
my lord. In the
No?
meantime, by
Thursday,
tomorrow I
no
can file.
business. List the matter on 29th of August.
Right.
I don't know what do you need to do is
Yes, yes.
file an
Yes.
application for impleading.
Implement.
And I'm asking you to file an additional affidavit. The reason is you bring in that they are approaching, then also they are not doing it.
Right.
There's a Supreme Court judgment which says that they are bound to do it.
Sure.
Read that.
My lord.
All right.
Supplementary item 52 to 54.
Devi Udyog and Bora 8 Jane. What has happened? Yes, Miss Jane. What has happened?
Let's say we have filed our affidavit.
You have filed affidavit in opposition.
Lordship, that affidavit in opposition was filed on Thursday. We
14
need some time to file a reply, if any, and get instructions.
Ms. A. Jane submits that as the affidavit in opposition has been filed on 14/8/2025, she requires 3 weeks' time for filing a reply. List the matter after 4 weeks.
55.
Yes, BTC. No BTC. Huh? No affidavit also filed.
Yeah.
I think we should direct the BTC person to be present, which official? Payment has to be made by whom?
Yes, BTC.
See,
Yes, BTC.
hello,
Work order, my lord, page 15, my lord. Work order, my lord, page 15, my lord.
page 16,
15, my lord.
additional chief engineer. And that person, okay.
Yes. Then, my lord, completion certificate, my lord, annexure 3, page 16, my lord.
None appears on behalf of the BTC when the matter is called. This court further have passed a specific order on 16/7/2025, directing the respondents to bring on record their stand by filing the affidavit on or before 14/8/2025. Full stop. No such steps have also been taken. Considering the above, for the interest of justice, this court directs the additional chief engineer PHE director PhD BTC Kokrajar to be present in the court.
My lord,
What is your instruction?
second time remainder already sent, but not instructed. Maybe dispose of, my lord.
They have not come, na?
Not instructed. The second time
None
remainder.
appears for the BTC now. Mr. R. Musari, the learned standing counsel for the BTC submits that even pursuant to the order passed by this court on 16/7/2025, intimation given to the respondent numbers 3, 4, and 5. Intimation have been given to the respondent number 3, 4, and 5, but they have not reverted back. It appears, therefore, that in spite of a notice being issued by this court and a categorical order being passed on 16/7/2025, the said respondent number 3, 4, and 5 have shown scant regard to the orders passed by this court. Considering the above, this court directs the instant writ petition be listed on 10th of September 2025. The additional chief engineer PHE director PHE BTC Kokrajar shall be present before this court at 10:30 a.m. through the video conferencing link to be provided by Mr. R. Musaheri, giving details as to whether the petitioner is entitled to the amount so claimed, and if so claimed, and if so entitled, when the said amount would be paid. Full stop. Mr. R. Musari shall provide the video conferencing link to the respondent number 4. This court further observes that in spite of Mr. R. Musari providing that in the eventuality that the respondent number 4 do not appear through the video conferencing link, this court shall be constrained to pass appropriate orders seeking his personal appearance, the physical appearance of this official on the next date so fixed.
56, 56.
Same, my lord. 56, same, 56.
56 also.
Same.
Same.
Did you? Somebody wanted to withdraw one matter somewhere? Oh, yeah. What are
33 and 34.
Somebody mentioned some matters. 40 and 41. Who only? So what are you saying? Some 33, 34. What is this?
37, my lord. 37. In the morning, I made a mention
Regarding-
Number 37. It's a contempt matter.
Oh, yes, 33, 34.
37.
But we have not taken orders till now. Have we started orders?
No.
And then time is. Yes. Where is the other person?
4041.
Then good. I'll be there. Next. Tiki, admission who will? No, admission who will? What is that 33, 34?
That is regarding settlement of market melon.
Huh?
Settlement of market melon. On last of all, it was directed to take instruction whether they will settle the market or it is decided to run the market by the authority.
Actually, we have received instructions. Standing committee. Standing committee decision.
Okay, 33, 34.
No.
So it is because it is awaited because of this section 81, the new committee have not been formed.
Lots.
That is the reason why.
That direction may be given to the authority.
What?
Direction may be given. Already the committee has been constituted.
Nine. So the decision will be taken by the standing committee.
Has been taken?
No, that's it. Will be taken.
As soon as the tender steering is formed, including other finalization of tenders in respect to a year would be completed. So, will be done. Let us wait for some time.
Lots.
Miss Enbora, hearing the standing council of the PNRD department submits that pursuant to the recent panchayat election, the newly elected Jila Parishad members the new Jila Parishad body have taken the responsibility of the Jila Parishad on 12/8/2025. On account of non-availability of the General Standing Committee constituted under Section 81 of the Assam Panchayat Act 1994, the finalization of settlement markets are still awaited. It was further mentioned that as the General Standing Committee is formed, including others, it is further mentioned that as soon as the General Standing Committee is formed, including others, the finalization of the settlement in respect of Santijan Bali Sokstra bi-weekly market in question, including others as per the NIT floated by the Jila Parishad Nagaon would be completed. The said instruction is kept on record and marked with the letter X. Taking into account the above, list this matter on 15th of September 2025. Let's have it on 15th or 15th, no? Or earlier to that, 11?
Maybe I'll leave it.
12th, huh?
15.
15th of September 2025. Full stop. For an update.
Pendency shall not be barred. In the meantime, they can be constituted.
What?
Pendency shall not be barred to finalize the settlement process.
It is observed that the pendency shall not be a bar for making the settlements in terms with in respect to the different markets which is the subject matter of the notice inviting tender dated 6/2025.
For orders, item 36.
In this case,
Pasoli, who appeared? None.
none,
Okay. So today I think we need to close.
the subdivisional level advisory committee approved the lordship.
Process cannot be completed, therefore please to comply. They are not bothered. Meeting of the so and so, so and so. The allotment has been given by the district commissioner.
Yes, lordship.
So this can be done. Does the state have to, the government has to take any action any further? No.
No, I have that I don't have that instruction, lordship. Only I have received this, lordship, from the
Then
deputy
you
commissioner.
can't submit like that.
Yes, lordship, but
I don't take
I
up
think
in
that's
five, that doesn't mean that you are going to take me for a year.
after lordship, that allotment of land, lordship, that that matter.
No, somebody told me one
Yes, lordship.
that in certain matters of certain area, the power has been delegated to the deputy commissioner.
In this case, lordship, that as per instruction of the circle officer, lordship, our revenue department has, lordship, the matter has been sent. to the
Revenue, where is the revenue department? No revenue, na?
Or lordship, list this matter after 1 week, lordship, I have to take instruction, lordship.
Last was listed in 2024.
Yes,
What is the
lordship.
direction?
The petitioner is also, lordship, absent. in-
Keeper has submitted, meantime, the deputy has instructed to submit a personal. So earlier it was 1 bigha. 1 bigha has been reduced to 2 kata
2
10
kata
lecha now.
Yes, lordship, 2 kota 10 less, lordship.
Why?
Earlier also, lordship, 2 kota 10 less, lordship.
No, earlier when I was taking up this matter in 2023, you were to obtain instruction as to whether the land was allotted to the petitioner or the Masqua vegetable retailer.
Lordship, that is, lordship, another case, lordship. There are just two, lordship, this, that Masqua is that, lordship, 2 bigha, lordship.
Non-APL so and so.
Masqua vegetable market, lordship.
Man within a month. No idea what is there to be done. Petitioner is not bothered now.
Yes, lordship, since 2020.
Here you are saying the sale allotment will be placed and accorded approval in the ensuing so and so. To be held in completion of demand. This is the direction path, let us.
Direction is, lordship, page
Having regard to the exponent are directed to expedite the, okay,
14
has been allotted in favor of, okay,
March.
allotment of land covered by so and so village under Zula in favor of Zilat, Olua, Hak Pasoli, Vibokai, Honta.
Posting Jalukbari.
Ati Zila, yeah, okay.
Yes.
Left. Miss D. Borman, the learned additional senior government advocate, have placed before this court the minutes of the subdivisional land advisory committee meeting held on 9/9/2024, whereby the allotment of land at measuring 2 kata 10 lechas covered by dag number 903 of village Kosim Jalukbari under Jalukbari Muza in favor of Guwahati Jilat Olua Hak Pasoli Bebohai Honstha was approved.
Yes.
The said communication is the said minutes is kept on record and marked with the letter X, taking into account the above. This court is the this court therefore, on the basis of the said minutes being placed by the additional senior government advocate, deems it that the land at measuring 2 Katha 10 letter covered by dag number 903 of village Posimgaon under Jolokburi Moja have already been allotted in favor of the petitioner number 1 in WPC number 6546/2014. This court further directs the District Commissioner, Kamrup Metropolitan District, to ensure within 3 months from today to issue the necessary patta to the petitioner in WPC number 6546/2000, petitioner number 1 of WPC number 6546/2014, so that the entire, so that the order dated 6/2/2025 passed in the WPC number 6546/2014 shall be deemed to be complied in letter and spirit. Full stop. Accordingly, the instant contempt proceeding stands dropped with the above directions. Ms. Didi Burman, the learned additional senior government advocate, shall apprise the present district commissioner, Kamrup Metropolitan, about the directions so passed herein above and seeking compliance. Full stop. Within the period above mentioned, the additional the district commissioner, the present district commissioner, the district commissioner Kamrup Metro shall file an affidavit of compliance before the registry of this court. The present contempt proceedings accordingly stands closed.
37.
You file an affidavit for compliance. Yes, another 2006, according to said in such cases, some inquiries were made and inquiry amount was deducted from the bill. That being the position, let the petitioner be furnished with the exposure and thereafter let the petitioner respond. Bunch of the also, what is it?
Ballot on
What are these we are going to do out here? What was the direction?
ballot page 7 of the
What is the direction passed by this court?
page 7 is the order, page 9 is the operative part.
To take urgent steps towards payment of the amount due to the petitioner as indicated above, 24,16,000. Entire exercise area. Payment of the due to the as indicated. You paid that amount.
Lordship, already see, out of lordship, 24,16,000 lordship, 7,78,000 deducted, remaining amount he has paid lordship.
Now, how can you deduct?
Lordship, this as per the police, earlier policy lordship.
Huh?
This as per the earlier policy lordship.
So nothing remains. Mr. Adhor appearing on behalf of the petitioner submits that the order dated 6/11/2025, 15 in WPC number 5621/2015 have been duly complied with. Considering the above, the instant contempt proceedings stands dropped. Mr. K. Gogoi appears on behalf of
Contempt.
the contemners.
Oblige lordship.
38.
Steps for notice of notice. Now, yes, what is this 38/2016 matter? Why is Union of India filing contempt? What is this
38.
contempt? Willful violation of an order passed by this court. None appears on behalf of the petitioner on call. It is seen from the instant proceedings. It is seen that the petitioner have also not taken steps as directed upon the sole defendant respondent. And as such, the present contempt proceedings have been pending since 2016. Further to that, this court is also the opinion that the allegations so made in the instant contempt petition do not appear to be a willful or deliberate contempt, deliberate violation to the orders passed by this court, thereby requiring the exercise of jurisdiction under the Contempt of Court Act 1971 or even under Article 215 of the Constitution. Consequently, the contempt proceeding stands dropped.
39.
Same order.
May I please, your lordship?
Order dated 26/5/2017. Okay, order dated.
40 and 41.
Yes, where is your friend for which you had
Lord,
to sit?
We have
Such
my lord,
a law.
instructed that the my lord, the relief sought for in the present writ petition has been provided to the petitioner. So virtually the matter has become in process.
Both? The council said, Mr.
B. Rahman.
B. Roman, you are for 6141.
No, no, my lord.
41.
7 to,
Mr.
7 to 5.
B. Roman appearing on behalf of the petitioner in WPC number 7251/2017 and Mr. M.U. Mondal, the learned counsel appearing on behalf of the petitioner in WPC number 6141/2017 submit that both the writ petitions have become infructuous. Ms. Yuda appears on behalf of the respondents in respondents appears on behalf of the respondent numbers 1 to 5. Taking into account the above, the instant both the writ petition stands closed as it has become infructuous.
Development.
42.
Contempt.
In this case, my lord,
2019, this court has duly taken note of the affidavit of justice so filed and from appears which has not been executed personally upon it. Have you taken steps?
my lord, respondent number 12 has been replaced by new incumbent, my lord. So,
Huh?
my lord, the respondent number 12 has been replaced by new incumbent, my lord. So,
You want to take steps?
my lord, so
Mr. Yu Das appearing on behalf of the petitioner submits the taking into account that the respondent number 12 has been Mr. UK Das, I gave you the same permission on the last occasion.
my lord.
Then you have not taken steps.
No, my lord, what happened, at first, my lord, we have to file application, my lord, thereafter we can file the implement petition to the respondent.
No, you are to file a petition or no,
Implement,
representation.
implement,
Okay.
for new incumbent,
You have to submit a representation first.
my
huh?
lord.
List the matter for 6 weeks
Obliged.
for the petitioner to comply with the order dated. Dated 25/7.
43,
B. Chaudhary, the learned
Yes, sir.
standing counsel appearing on behalf of submitted you obtain and whether the author has complied. Yes, everyone complied with or not?
Lordship, this item I have missed it, Lordship, may take it up next week, Lordship.
No
Pardon.
problem. 10,000 cost?
No,
Today, in the whole day, I have not given anybody cost. So let me start with the day.
it was my fault, Lordship, my fault.
I'm not imposing the clause upon the client. I'm imposing upon you. Mr. B. Chaudhary, the learned standing counsel submits on behalf of the respondent number 2, submits that he completely lost track of the instant proceedings and as such is not aware, didn't bring the file. First of list this matter on 8th of September 2025. The respondents shall, Mr. B. Chaudhary shall without fail obtain the instruction and so on. All right.
44,
Complied?
Lordship, there are some issues, Lordship.
And I say that to be 5 lakhs to be
Lordship, last page, Lordship.
So out of 27 lakhs, he's entitled to.
It was originally about 44 something, Lordship. But half of the amount has been paid. Now balance is 27,600, Lordship.
27 lakh.
Yes, 27 lakhs, 6,000, Lordship, out of which 5 lakhs was supposed to be paid in the month of March.
Go and take that money.
no, sir, I have not been paid, no communication.
Understood. Go there to the office.
They have not communicated me anything, Lordship, that whether they have intent to give 5 lakh, this is their own record only, Lordship. They have not communicated me anything, that we are giving this 5 lakhs to you. They have not given, Lordship.
Lordship, on the
Mr.
earlier,
B. Chaudhary appearing on behalf of the BTC,
yes.
appearing on behalf of respondent number,
So, respondent number 1, Lordship.
respondent number 1 submits that out of the total amount to which the petitioner is entitled to, that is 27 lakh 60,000, an amount of rupees 5 lakhs have already been sanctioned and the check in that regard have been also drawn up. However, as the petitioner PAN number, GST, income tax, bank account number have not been received, the said amount could not be forwarded to the petitioner, or said amount could not be disbursed to the petitioner. In that regard, he has placed before this court an instruction which is kept on record and marked with the letter 6X. List this matter on 17th of September 2025, on which date the respondent shall also apply this court as to when the remaining amount of rupees 22 lakh 60,000 will be
Lordship,
disbursed.
may kindly peruse the last page, Lordship.
What is that? What is it? You pay without any account. You're not concerned whether there was a direction to pay by Tamsir Ali.
No, Lordship.
It was not
There
that.
are no direct, that is your own, Lordship.
No, no, no. Tamsir Ali, nothing. They'll give a prize this court on the next date as to when the remaining amount of rupees 22 lakh 60,000 would be paid to the petitioner. Full stop. In the meantime, this court directs the petitioner to visit the office of whose office?
Lordship, it will be Director PNRD.
PNRD where? The director, PNRD, PTC,
Yes.
for along with the PAN card, GST, income tax, bank, AC, etc. For the purpose of disbursement of the amount of rupees 5 lakhs, which is lying with the receipt respondent. Is a respondent, na?
Yes.
Respond number?
Lordship, here it will be respondent number 2. 2 and 3, Lordship.
Specific lordship. He has to specific to
Before whom he should go?
Lordship, let him go before respondent number 3.
Take that 5 lakhs, get more energized and fight for the 22 lakhs. Another contempt, others have been submitted to the Lord filed in FP, however, the same is not according. Yes, affidavit in reply, we see fine.
My lord, kindly produce the order dated 20 June, my lord, 20 June,
20 June,
Yes.
considering the trend, it's the effect that if you only money paid and. Yes, payment, who is appearing for the respondent?
I am appearing for newly implemented respondent number 3, madam. I am the district commissioner, madam. Madam, the payment has to come from PNRD department, then we'll disburse. We are the disbursing authority. And regarding the amount, there is
Is
some.
the PNRD department a party? Whether the direction was
Yes.
given to the
To the
PNRD?
commissioner, my lord, page number 9, your lordship, order.
A commissioner is there, who is respond number 1, who is he? 1 and 2, who is appearing? Why the payment has not been given? Huh?
Lord, we have received one instructions. We have already sent a letter to the director, Mahatma Gandhi NRGA, Ministry of Rural Development, Government of India, for approval against the schemes in connection with this 14 numbers of schemes.
My lord, on 28 June, my lord, it is categorically.
You have never stated when the instant writ petition was filed as to what is the amount.
On 28th
Now the
June,
payment has to be made to whom?
made to the petitioner, my lord.
Why?
On 20th June, my lord, they have, my lord, categorically, my lord, on 20th June, submitted that they have already released the amount, my lord, my lord, 65,062 as per their verification, my lord, that I am entitled for 65,062, 513, my lord. 20th June 25 order, my lord, it's particularly mentioned, my lord. To the account of the deputy commissioner, my lord, it is mentioned, my lord. Out of my claim was 76 lakh 18,804, my lord.
There is some dispute regarding the amount.
Yes, 26/2025. It says that the amount has been deposited to the deputy commissioner's of account through the PNRD department.
No, madam, we have not received that amount.
What is this?
I have filed the expected.
What is this? This can't happen like this.
Lordship, we have received one instruction.
Now, we are not going to look into all these things. In view of this, either Mr. S. Dutta was not properly instructed, but he has made a statement which has been duly recorded. So whom should we draw contempt? The Commissioner PNRD or the Deputy Commissioner?
Well, I have filed my affidavit. I have taken the.
So that means the Commissioner PNRD is false or you are somebody is
Lordship,
lying.
Lordship,
Somebody has to, because one says that payment has been given, other says the payment. So I think that we should get hold of Mr. S.
Lordship.
And if he has made submission which have been recorded without instruction, then we should take action, initiate contempt against him. We filed one application for impeding Mr. S. Dotto, advocate. For making false statement. Better. This court have duly taken note of that on 26/2025. Mr. S. Dutta, who had appeared on behalf of the respondent numbers 1 and 2, had made a categorical submission that an amount of rupees 65,62,513 has already been deposited in the account of the Deputy Commissioner's office through the PNRD department. However, the affidavit so filed by respondent number 3 shows otherwise, inasmuch as the said amount have not been received. From the above, it therefore appears that the respondents in the instant proceeding have not given a clear picture as to before whom the money, the amount of rupees 65,62,513 is lying. Considering the above, we dispense with the appearance of all advocates in the council for the respondents and direct all the three to appear before this court. Somebody must have been lying out there.
My lord, I want to clarify this stay, my lord. I want to file one affidavit, short affidavit, my lord. To clarify, I'll tell why I have stated on that day, my lord.
Why you stated that?
My
day?
lord,
No, it has
I have
been
some
reported.
instruction, my lord, in earlier on that day, my lord. That instruction I was, on that day, I have that instruction. That in compliance of the court's order, my lord, we have requested the district commissioner, my lord, to comply with the court's order. And my instruction was that, my lord, on time to time, we had released the amount to the district commissioners, and accordingly, they used to release to the petitioners. And now they inform, my lord, they don't have much amount to release. Therefore, we have requested the central government, my lord, to approve those schemes, my lord.
No, we are not concerned with that. We are not concerned with that. This is something is wrong.
And actually, I don't have the copy of the affidavit of the district commissioner also, my lord, so that.
It therefore appears that the stand which have been taken by the respondent as to who is presently holding the amount of rupees 65,62,513 to which the petitioner is entitled is not clear. This court therefore direct all the respondents hearing to settle amongst themselves as to who present among themselves. As regards the amount of 65,62,513 and submit before this court as to when the said amount would be paid to the petitioner.
Right.
List the matter. We need it before Puja, na, Mr. Kadir?
Yes, my lord.
That's on 10th of September 2025.
My lord.
Obliged.
Hello, please.
I'm not going to look into all these, the other.
My lord,
documents.
I'll take
I'm
care
not
of that.
concerned where money you have to get it.
My lord, I'll take care of it.
Otherwise, be ready for initiating contempt for you also, Mr.
My lord, my lord.
Doctor. I don't mind.
My lord,
Initiating contempt upon lawyer. Yes.
My lord, there is a
Yes.
petition, my lord, which says, based upon.
Why are you filing review?
Review, my lord, there is a, my lord.
Review for what?
And it's
It court have passed the state directive. Better. Yes. What is this?
Yeah, Your Lordship, I am appearing today by filing my wakalatnama. NSPC council will also be required because NSPC now comes up and says that the Ipamu project.
What direction I gave?
Your
Direction,
Lordship,
Lordship, madam.
just see para 6.
Page number 30, Lordship. Page number 30.
They came up for regularization that Your Lordship has said that it's not cannot be granted. However, para 13,
13 and 14, Lordship.
Your Lordship has granted a direct.
Grants the liberty to submit the representation before the chairman and managing director of the fund number 5. And upon such representation so submitted, this court requests the year of demand to take up compassion to the representation so submitted and pass appropriate direct order as may deem proper in the exigency of the special. 5. The land council appearing on behalf of the submitted representative will be filing the representation within 30 days of the day. Now, you see, you say that you wanted to, I directed you to file before response number 5. Whom should have directed? As per you, whom should I have directed?
Lordship, my lord, kindly come to the page number 85, Lord.
I'm not concerned. Whom should I have directed?
As per my lord, opposite party council instruction, Lordship, we have met this party, my lord, the respondent of implemented. Originally, my lord, it should be my lord to the NEPCO, Lordship.
No, whom should I have directed?
To the my lord, respondent number, Lordship. NEPCO 1, 2 and 3, Lordship. 2, 3 and 4, Lordship.
I directed to whom?
5.
Lordship 5.
Nestle Hydro Electric Power Corporation, NHPC.
Yes, sir.
I should have directed to NEPCO.
Yes, sir.
Response number 2.
Yes.
That's it.
Yes.
Your Lordship, what has happened?
Consider it.
No, Your Lordship, there's a slight problem in here. What has happened is that they are seeking regularization on basis of an MOU in respect of a project called Tipamuk project. That was initially with Brahmaputra Board, then it came to NIPCO, then the government of India has said that a joint venture consisting of NSPC, government of Manipur and SJV will take over. In 2013, my instruction, which I'll have to now place, that was in 2009. 2009, it was handed over to NSPC and the joint venture was to be constituted. Thereafter, in 2013, NIPCO has come out of everything of that. So the project per se was initially with NSPC after 2013. So as on 2025, our submission before Your Lordship was that since the Tipamuk project is no longer with us, question of regularizing them on the basis of the MOU will not. Even the writ petitioner may not have the necessary instruction. If Your Lordship see para 2, even as on date, they say that they are working in Tipamuk project. Now, para 2 of the page 10, paragraph number 5, page 10. It is stated by the petitioner, if I'm bottom of the paragraph 5. Para 5, page, it starts at page 9, but page 10 may be seen, bottom 3 lines. It is stated by the petitioner that the petitioner are continuously discharging their duties
as master role worker at Tipamo project to the satisfaction of all concerned. And para 13, your lordship's order, if your lordship just see your lordship's order, is the ladies. This court has given conscientious consideration to the matter in is also of the opinion that taking into account that the petitioner has been rendering the service in the Tipamo project. So the entire thing was of Tipamo project. Now, if the Tipamo project is not there for it, then this direction also falls.
No,
Because
no, I said, okay, but the question is, that day I was very kind enough to issue that notice, now Mr. Gogoi. I didn't they say that this is a fresh cause of action? You don't consider what to I do. First, I can't grant you regularity.
There is there, my lord.
Anyway, earlier affidavit,
As per case number 85.
Mr. So-and-so appearing on behalf of the respondent number
234.
234 submit that he would like to file affidavit. It's the matter on 3rd of November 2025. In the meantime, the affidavit be filed by 24th of October 2025. Liberty given to the petitioner to file reply.
Matsuk.
51. Malad service upon OP is not complete.
What is this?
This I is filed for implement.
Implement
Yes, my lord.
of
OP. OP number 1, my lord. The Escort Bank has been taken over, went on liquidation is, we want to implement liquidator as opposite party. Service is not complete.
service not complete. Service being not complete is the matter of the petition.
57.
Mr. Sharma, what is this?
My lord, this was for resumption of electricity connection, my lord.
Oh, what happened?
My lord, we have taken Dusty on respond number 6. I have an acknowledgement. In the meantime, the petitioners have also applied for a fresh electricity connection. The APDCL is yet to process on it. The APDCL is yet to process on it. They're working, my lord, in good faith. There is no dispute to that. In fact,
My lord, they have filed their application today itself.
What?
They have filed their application today itself.
Why? What is wrong?
no, my lord, what has
Why?
happened?
After passing an order, I know it.
No,
This
absolutely.
is the way out by which I got him, Mr. Who was appearing?
B. Chaudhary, my lord.
Mr. B. Sharma.
B. Chaudhary.
B. Chaudhary has categorically said that we have no objection.
Yes.
I recorded it in the order
Yes, my lord.
and asked you to file.
My lord,
Why didn't you file?
no, my lord, what has happened, my lord? My lord, there was small apprehension on the part of the petitioners. So what they have done is that respondent number 6, Dipasa Thakur, who resides in Jorhat, they have requested her on their behalf to apply for a connection. That is why the to and fro from Jorhat to Guwahati had taken time, my lord. The application was on the behalf of the petitioners. What the petitioners have done, the issue here is that the shops are very small. Only 1 kilowatt is needed. Now for 6 different shops, 6 different main meters cannot be installed. There is some feasibility issue of the APDCL also. So 1 meter has to be installed for all the 6 shops because the shops are, my lord, not bigger than these 2-3 podiums taken together. And that will not need 1 meter for itself. 1 meter can suffice for all the 6 shops. That is the issue with,
Halogens out there.
my lord.
Put halogens out there instead of using LED light.
Yes.
Electricity will go more than 1 kilowatt.
No, no, it's so that is one small issue, but we have taken steps.
Anyway, what do you want?
My lord, your lordship will fix the matter in 2 weeks' time because then we'll have to file our affidavit also. Respondent number 5 has refused Dusty. So in the meantime, to ensure your lordship's compliance, I've taken registered post steps also.
Have you filed the affidavit of
No, I just received it today from respondent number 6, Vipasa Thakur. I had it served by way of the petitioner number 1. So my lord, lordship will give me 2 weeks' time to file the affidavit and ensure compliance of your lordship's order. There was that small issue of feasibility that is, yes, my lord.
Let's the matter again on 15th of September
Yes, my lord. Yes, my lord.
2025.
I'm grateful, my lord.
It is observed that the pendency of the instant petition shall not be a bar on the part of the FPTTL authority to provide separate meter to the.
I'm grateful, my lord. I'm grateful.